Is there?
My lord, your lordship, on the last occasion on 26th was pleased to direct that this matter would come under the heading upgraded motion, because that time it was appearing under the heading upgraded motion. It was item number 16, my lord, but somehow it is not appearing as upgraded motion, your lordship.
What is the matter? What is the urgency?
BSNL, your lordship might kindly remember, BSNL was made
I
part.
think কত?
My lord, paragraph 5, your lordship was pleased to observe in paragraph 5.
এই করে দিও, তুলে দিও, আপডেট করে দিও। Yes.
And my lord, one matter, my
No,
lord.
no, no. Yes.
Yes, may I be permitted, ma'am, for mentioning for upgradation.
Yes.
Urgency is ex parte appellate order has been passed, and they are verbally pressurizing us for making payment. And
GST.
GST. Yes.
Sir, ordinarily there is no tribunal. You wait. Without the tribunal, they cannot enforce it today. Yes.
My lord, may I permitted to mention two matter, my lord. First is item 1205, as this in this matter interim order expired, and on
And the interim order expired, so you have to file an application.
yes, my lord, and I
File an application and hand
yes,
over the
my
slip.
lord, I already filed can
Hand over the
application.
slip. It will appear.
And
Yes.
my lord, on second matter,
Hand over. No. Yes, madam.
My lord, I would like to mention two matters. These two matters, your lordship had allowed it and were appearing as upgraded motion also, my lord.
What happened thereafter?
My lord, thereafter on Thursday, one matter was there in serial number 12 and other was there in serial number 15. But in monthly list, my lord, it has gone down to 800.
It has not been called on, madam.
Yes, my lord.
It has not been called on. No order has been passed. Are you sure?
My lord,
Are you sure no order has been passed?
my lord, I was arguing, my lord.
No, online I will not allow now. Yes.
My lord, in one matter, there is no order passed. But in another matter,
Which in the matter which no order has been passed, kindly hand over the slip. It will appear as upgraded. It was continuing to appear as upgraded.
my lord, another one, there is issue of yeah, audit consultation. We have challenged the audit.
What order has been passed in that matter?
My lord, may I clarify, my lord, since I am appearing in these matters to this court.
You can't mention on online, sir. There is a procedure. You have to follow that procedure, Mr. Sharaf. Then if I allow you to mention on online, then what is the difficulty in permitting others to mention online? Yeah, understand. I'm allowing
I
every.
was not aware of this, my lord. That your lordship.
I will allow you to mention online after the advocates who are present in court.
Right, my lord.
They're mentioning. You have
Then I will ask my junior to wait, my lord.
to wait for your turn.
Yes, ma'am.
the matter was filed on 14th cancellation of registration. My lord, the business is stuck for 2 years, and
Cancellation of registration passed by the authority. Thereafter, you prefer an appeal? Yes.
And ex parte order has been passed because the department has not served proper notices of hearing.
Hand over. Yes. Yes, sir. Yes, sir. Yes. Hand over. Upgradation. Daily cause list will not happen. Yes. Daily cause list will not happen. It will appear in the monthly list only. If it is not appeared, hand over, it will appear in the next monthly list. Hand over. Hand over. Yes, yes. Hand over, hand over. When was attachment? When? This year? Hand over. Yes, ma'am. Miss Mukherjee. Upgrade. কবে বলবো আমি পরে, তুমি আপডেটেড গুলো হাতে রাখো, কবে আমি পরে বলে দেবো। August 2024 can't appear. Madam, hand over, it will appear next month list. Thereafter, allow upgradation. Appearing in the list. Item number? Yes, what are you challenging, madam? Under the Customs Act? Under 129? Thereafter, you did not seek for release of the goods? Hand over, yes. दे दो, yes, दे दो, दे दो. Appellate order. Wait. When you take your chance, you ought to prefer an appeal from that order. Why will the court entertain the petition? If the appellate provision is there, proceed with the appeal. Yes. Non-payment. No. Hand over.
My lord, may I
It's
be?
the only ground. Appeal. Let us see. Wait.
Your lordship.
What is so urgent about the matter? Very well. Let them issue summons.
Yeah.
Let us see what happens. Yes.
It's number 808, my lord, of today. My lord, in this matter, we have challenged the demand made by the excise authority. So during the pendency of this writ petition, in spite of pendency of they are issuing demands saying that since there is no stay, we are please have paid this money, otherwise initiate recovery proceedings.
Let them initiate. Let us see.
My lord,
What
may
is
uh,
the item?
Item is 808.
Let's see. Let's wait for a while. Wait for a while. Let them initiate it. Wait for a while. Let me find out.
My lord, may I be?
If this matter can be taken up anything.
Let's see, sir. Wait for a while. Let us see how it proceeds. Yes.
My lord, may I be permitted to mention one matter for
Madam,
upgradation?
kindly stand back because you will not be mentioning. Your senior would be mentioning. Allow others to come forward. Yes.
My lord, may I be permitted to mention one matter for upgradation, my lord? The registration certificate of the petitioner has been suspended and it is getting difficult for the petitioner to carry on his
File application for revocation.
Your
Yes.
Lordship, I would like to mention a matter for inclusion of the list. As per the last order, it was mentioned that it will appear in the monthly list of December.
दिए दो list. For a month.
Your Lordship,
For a month दिए दो.
Lordship,
Yes.
may I mention this matter for withdrawal?
Yes. Hand over. Withdrawal बोले. Withdrawal. Hand over. Withdrawal. Just hand over. Write down withdrawal and hand over the slips for withdrawal. Don't need to mention.
My lord, may I be permitted to mention
Yes. Hand over withdrawal first. All withdrawals. Yes.
fresh matter, my lord? It's filed on the writ petition was filed on first and given on 4 April. However, it is not.
Will appear. Wait.
Is that
Madam, let it appear. Otherwise, I can't hear the urgency. First of all, the matter has to appear in the list. It will appear. You have given a date, 4th.
my lord? However, it is
देखो,
not.
देखो. Find out from the department. Maybe there is some difficulty out there. Check up the notice board there. Yes. दिए दो cooperative है मामला. Upgradation next week, madam. Cooperative next week, not this week. Yes. Cooperative. Hey, Bosho, Prosenjit, Bosho. Hearing matter, I'm not taking up. No hearing matter, I'm not permitting inclusion. Hearing matter, I'm not permitting. Yes. Next. Yes, hand over. Yes. Any other mentioning?
My lord,
Hand over, madam. Restoration not necessary to mention.
my lord, I mentioned.
Yes, what upgradation? What is the urgency, sir?
Expel my directorship.
How many matters are there in the cooperative side? How many matters are there in the list?
70 matters I have.
So why are you mentioning? Can't you wait? 70 matters this month it will be called on. Don't mention. 70 matters are there. And I'll be taking up those matters on 2 particular days a week.
Meeting will be held on just this. That is why.
That I cannot help. You have to wait. When is the meeting held? When is the meeting fixed?
Coming Saturday.
Let's see on Tuesday what happens.
Last item, this is 195 item. Last item of property. That is why I am.
Thursday to nahi, cooperative society. Huh?
Tomorrow is
If it is not taken up on tomorrow, then again on Thursday, there is another date. You take your chance then. If it is not taken up tomorrow, may indicate in the evening. Yes.
My lord, this matter pertains to arbitrary issue of notices under section 148 of the Income Tax Act. Now the department.
What arbitrary? What is the arbitrariness?
They have challenging. They are alleging that we have entered into sham
You are not being
transactions.
solved with the notice under section 148 capital AB.
Yes, sir, we have been.
Then what is so arbitrary about it?
The order has been passed. The notice has been passed without any citing any reasonableness or explaining the reasons for issuing the notices, and they are alleging sham
Unless you are in a
transactions.
position to demonstrate there is a procedural irregularity, I will not admit, because you have an appellate provision ultimately.
My lord,
Nothing is going to be decided now.
Now they have issued.
And if you say so, that you were not happy with the order passed under section 148, that cannot be a ground for challenge. You have to wait. You may not be happy with the order. That does not
My
necessarily
lord, the
mean.
arbitrariness is evidently prima
What was
facie
the
evident.
defense you raised? What was the defense? What was the ground on which
They have
notice was issued?
They have cited a bank statement in which they allege that we have entered into a transaction worth rupees 30 lakh rupees, a single transaction on 4th of April. But there is no such transaction in the statement itself. And still they are alleging that we have entered into the transaction.
Let it be tested out. What is so difficult about it?
We have represented before the department, but the department is premeditated and they are not paying heed to any of our
No,
submissions.
I cannot solve everything. Whatever is there. Item number?
Item number 524, my lord.
Yes. Upgrade kore dao next week. Hand over. Consequences are very severe, sir. Please take your chance. Yes.
My lord, I'm praying for upgradation. There are some recovery notices that have been issued against us. And I'm praying
There are some.
recovery notices that have been issued against us. And I am praying for some interim protection, my lord.
Which provision?
My lord, under
GST.
GST.
Hand over. Yes.
My lord, may I be permitted to mention two
When the recovery notices were done, when the recovery notices were issued?
Recovery notices were issued on June 2024.
2024. We are in the year.
2025.
Why you have come after so much? What is the delay?
My lord, the writ petition has not yet been heard, my lord.
Take out an application. This cannot be an urgency. It will be taken up in usual course. 2024 recovery notice. Ferot diye dao. Yes.
Application has been filed. Interim application has
Yes.
been
Interim application will appear. I'll take up the interim application, not the writ petition. No, not it will not be upgraded. Interim application I'll take up. Yes.
My lords, may I be permitted to mention two matters? The first matter, my lords, I had mentioned last week, my lords, it had been upgraded, but it not had reached for hearing, my lords. The urgency is that, my lords,
It had not reached.
it had not reached, my lord, and not.
Yes.
And my lord,
Yes.
Matter for upgradation, we have challenged the bank attachment. My savings bank has been attached.
Sir, you are sure it has not been reached?
Yes,
Yes.
sir, it is
Have you indicated the item?
yes, my lords, it's serial number 834.
Yes.
item number 335, it is appearing in your.
আপডেটেড গুলো পেছিয়ে দিয়েছিলে কেন? তো যেগুলো ধরেনি সেগুলো তো রাখতেই হবে। এগুলো ধরেনি।
Your Lordship, my savings bank account has been attached. In the month of December, I made my representation in DRC 22A opposing the provisional attachment, but the department is not replying, and hence I filed this
Under which provision?
section 83 GSTL.
The first one is for upgradation. Lordship, this order has been passed in gross violation of principle of natural justice. We requested during the proceedings for cross-examination. However, the request was completely brushed.
Let us see, madam. Wait now.
Your Lordship, matters for inclusion in the list.
One only mention.
Investigation amplified, rejected on the grounds of change. That should be given.
No. Upgrade. Yes. Handover. Restoration is separate. Handover. Restoration, withdrawal, এগুলো অন্য, এগুলো only I am here. I will hear upgradation. Yes.
Nine of the years was upgraded earlier. My lord, this matter what has happened is by it's a GST matter where an addition has been made on the same issue which was examined earlier. This time, I don't know, the same issue for the same year, the department.
Urgency.
The department has indicated that it will initiate recovery proceedings.
They are not yet initiated. Let us see. No, you have already mentioned your chance is over. Not yet initiated recovery proceedings. Let us see. Let us go. Yes. Yeah, not hearing matters, don't mention. Yes. Until further notice, don't mention hearing matters.
Mention one better one last on regarding the list and item number 60. Sample the matters came in the part of item 820.
Item number?
Item number 822.
Previously?
Previously, item number 60. Certainly the matter.
Why? Find out any order has been passed in the matter. Check. Check. Yes.
Order has been passed. Under the heading HON'BLE motion and matter, order has been passed on 27/3/2020.
What order has been passed? What order has been passed on that date?
Well, the interim order has been extended.
It is all right. Yes, let us see. It was for extension of interim order. It was appearing. Why are you saying urgent motion? It was appearing under the heading extension of interim order. So it has gone back to its own position. Yes.
Permit to mention one matter for
Your interim order has been extended. What do you now want to be decided today?
for application, my lord.
Yes.
Item number 116 of the monthly list. The urgency is, my lord, the
116. Wait for a while. Let's see. Up to the yes. What is your urgency?
urgency, my lord, that the input credit ledger of the petition has been blocked by the authority. That's why, my lord, the petitioner is not able to file its return. This is the urgency, my lord.
Why?
Because on the basis of the allegation that the selling dealer was non-existent, the department
Your
invoked
registration has been cancelled, suspended.
no. The
Your registration has been suspended.
not registration, my lord. The selling dealer was not existent at their place. That's why they have by way of invoking the rule 86A, they have blocked our input credit ledger, alleging that we have misused such, we have taken the event as such ITC.
You know,
Item number 774, my lord.
Arjun. Agree.
For application, my lord, the urgency is that petitioner is a citizen from Bangladesh, my lord. He for his treatment, medical treatment, he came to Kolkata, my lord, and at the time of boarding, my lord, his gold ornaments seized by the custom department. Till now, no communication.
How many tolas of gold?
212 grams, my lord.
212 grams. She was carrying. She was
One-
carrying to India.
Yes, my lord. Ornaments, my lord.
Ornaments. 212 grams ornaments.
Yes, my lord. Well,
What treatment she was coming to Calcutta, sir, madam? What
Well,
treatment?
for some medical.
With the jewelers? Any appointment with the jewelers she had in Kolkata?
No, my lord. For his.
When
medical
was it seized?
We are
When was it seized?
2023 to April, my lord.
Ask for provisional release. Yes.
My lord, we have many communication has been made by the petitioner, my lord. No steps have been taken by the custom department, my lord. Till the 2 years have been passed, my lord.
Let us see what happens,
Well,
madam. No. These matters can't be expedited. 2023 has been seized. No. Too late in the day. Yes.
Your Lordship, may I be permitted to mention this matter? Your Lordship, it's a covered matter. It pertains to Rule 96.
Next week.
Your Lordship,
Covered matter, not this week.
Can we
I will
permit me to
disallow
mention-
Justice Mr. Ghosh. Yes.
Can we permit to mention this
Come
key
next
matter?
week. Yes.
I am praying for the application matter. In this matter, the demand order has been passed without issuing the show cause notice. And now the department initiated the recovery notice.
Very well. File an appeal. There is an appellate provision. Yes.
2023 matter, Lordship. The dates to the Lordship referred. Lordship, 59 lakhs is the refund amount which is involved, your Lordship. So matter is not for hearing. Lordship, 1007 is the list number, Lordship.
These are hearing matters. Yeah, no, I'll not appeal. Yes, come. Yes, quickly, sir.
I tender my apology.
What have you done?
Friday, I had mentioned this matter.
Yes, you ought not to have mentioned this matter on Friday. Yes,
I beg your pardon, my lord.
yes.
My lord, in WPA 30537 of 2024, I was appearing for the Union of India. It was a hearing matter of item number
What do
9.
you want, sir, today?
My appearance has not been recorded.
File the bill call, देखी कब है ऐसे?
My lord,
Yes.
my RC was cancelled, my lord, without
It is
assigning.
good. When was it heard?
It was heard on 6/3/2025.
6/3. Last week was not much.
And it will come on 10th April 2025 once again. Mr. Akshay.
When it appears, you then mention. When it appears again, you mention. It will be better. It's not have to be mentioned. I'll not please. The honor.
Can I hand over the copy?
When it comes, you mention. When it comes in the list, yes, yes.
Sir, may I be permitted to mention one matter, my lord? RC was cancelled without assigning any reason in the show cause, my lord. And they
Yes.
are not doing any business since last 2 years, my lord. It was running under 654 of
What
the
was the grounds for
previous
cancellation?
no grounds assigned on the show cause notice, and no ground on the order, my lord.
Have you applied for revocation?
No revocation not applied.
Yes. Unless you apply for revocation, I'll not take up.
No, it is running in the list, my lord.
Maybe. Yes.
Milords, may I be permitted to mention a matter which is not appearing in the cause list, Milords? This is, we have challenged the order under Section 83 of the GST Act, Milords, for provisional attachment. They have provisionally attached my bank account. Apart from that, Milords, they have issued orders to my sundry debtors to not pay the debt amount to me, Milords. This has happened on the January 29, 2025.
They are entitled to do that.
Milords, without notice, Milords, they have they have not provided me an opportunity, Milords. And the problem is now,
every stage they'll provide you opportunity.
Milords, I have been rendered paralyzed, Milords, because I don't have any capital to run my business, Milords.
There is initially an order against you.
No order. This is without an order of adjudication or demand, Milords. And the
May I be permitted to mention, ma'am?
Much obliged.
Mentioning for inclusion in the list, where file and-
Inclusion.
Yes, sir.
Next month is hearing matter.
No, my lord, application, my lord, for extension. of
Application handover. It is not necessary to mention.
For relisting of the matter was running in the list, the month list of March 2025. The matter was called on 25th of March 2025, my lord. And I was out of station, my lord. Nobody appeared on that day, my lord. My lord was directed to delist the matter. And I'm praying for before Lordship kindly.
Nobody appeared.
My lord,
And on the second or the third day, I had done that.
No, second, what happened, my lord, 24th, 25th, and 26th, I went to Darjeeling because my son was admitted in the St. Paul's school. Grateful.
রাখো ওটাকে আলাদা করে আমাকে পরে দেবে দেখে আলাদা করে রাখো পরে দেবে
Great. Lordship, may I just kindly mention, my lord, four.
আলাদা করে রাখো
See, I have mentioned, my lord, 4 matter, my lord. 3 matter, my lord. I will mention last week.
Don't mention 4 matters. Mention individual matters, Mr. Rai. Individual matters.
My lord.
No, not in a bunch, Mr. Rai.
My lord, these 3 matters mentioned last week, my lord, that can file against recovery notice. Recovery notice issued by the same officer.
Can you hand over? I will not hear mentioning.
May I have
Or
the-
can mentioning hand over.
Kindly to mention item number 188 and 366 of the monthly list, my lord, because these two cases are for the GST cancellation, registration cancellation for non-filing of return, my lord. After appeal, I have come, my lord.
Hand over, yes.
Application. Grateful, your lordships. Lordship, order passed and by the order of the that appearing in the.
Hand over, monthly list, next monthly list. Monthly list দিয়ে দাও. Yes, yes.
Your lord.
Matter has appeared once.
Hearing ছাড়া দেবে নাকি? Hearing হলে দেবে না, দেখে নেবে.
Listed notice appeared actually 3 times. It's called up. Now, two occasions. For German and the appointment. Well, recovery notice.
Monthly list, next. There in the list, no. Not there.
It's item 171. I bring for application.
And ফেরত দিয়ে দাও. It's there in the list. Why are you mentioning?
Recovery notice.
You lost your chance. Sorry, sir. I
May I
can't
be
help.
permitted to mention a matter for upgradation. Petitioner's GST registration was already cancelled.
171, you take your chance. It will be likely to be reached. Yes.
Your lordship,
Yes.
petitioner's GST registration, my lord, is already cancelled. Kindly lordship.
Very well. What have you done thereafter? Prefer an appeal, file an application for revocation?
Yes.
What ground?
Lordship, my GST.
Ground for cancellation.
Lordship not filing the returns for the past 6 months. Lordship.
Madam, you are not permitted to mention online.
Lordship, it's assisting my.
Are you sure?
She is appearing.
No, madam, then you should wait. I'll not take up the mentioning now. Sorry, I've already allowed you. Yes. Yes. Madam.
May I be allowed to mention for upgradation, your lordship, the matter has been filed on 18 June 2024, but not taken up for hearing, your lordship. Your lordship, the entire adjudication process is ex parte, your lordship. No notice has been served and everything. That's why we haven't filed.
Item.
Item number 541 of monthly.
সেকেন্ড গ্রুপে দিয়ে দেবে যদি হয় তখন নেব এখন দেবে না মানে 2 বলে দেবে 2 লিখে দাও উপরে তাহলে আমি দরকার পড়লে নিতে পারি, এক্সস্ট হলে নেবো, নালে নেবো না, 2 লিখে দাও। ইয়েস
My lord, this matter was running as item 16 on last Thursday, my lord, under heading urgent motion and not reached, my lord, and it's now on monthly list item
yes.
823.
Yes, madam.
May I be permitted to mention one matter? My lord, 80, item number 806 of monthly list. My lord, most urgent matter.
What is the urgency, madam?
Urgency is, my lord, adjudication of 26 crores is pending before the assessing authority.
Very well. What is so urgent?
Urgent, my lord, outcome of this read is depends on the outcome of this read.
No. Yes, yes. Yes, Mr. Sharaf. Yes, Mr. Sharaf.
My lord, item 833, my lord, of the monthly list, it was running as urgent motion at item 12, my lord. It was never called out.
Never called on. Are you sure?
No. Yes, my lord.
833. Yes.
And my lord, item 814, my lord. 814, my lord, your lordship, it is a customs matter, my lord.
You can only mention once. You have to give others an opportunity.
My lord, because it was running in the upgraded list, that is why I am mentioning, my lord. Otherwise, I would not have mentioned.
Order was passed there.
Yes, my lord. The order was passed, my lord, directing the customs authority to take instruction and to list on 6th March. Thereafter, it has been running in the supplementary list and the upgraded list, my lord. But it never reached, my lord. That is the difficulty.
Well, I'll look into this next year. Yes, madam. Yes, madam.
Well, Lordship, may I please mention a speaking for the minutes for rectification? My lord had passed an order on the 27th of March, but there's a small mistake where the assessment.
148 has gone there instead of 48.
No,
48.
Assessment here has been mentioned in the order, which is wrong. That's it. The rectification.
You mentioned. Who is there? Who is there? Hand over. Yes, you mentioned.
Your lordship, may I be permitted to mention this?
Number 1 of the
on several dates. It was directed to be listed for order.
Yes, yes. You wanted to mention. Yes.
This matter, it was filed on 27 September, not yet called once. And it is
27 September, item number?
Item number running as 708 of the monthly.
What is the urgency?
Urgency, Lordship, this is a customs matter. Lordship,
call her.
Never called once also, Lordships can verify. What has happened, Lordship? All 24 matters. September, October has gone down now. Lordship, kindly sees the cause list. It is coming like that. The new filings are coming up.
No.
Lordship, it is
only if it is called on, then only it will go down.
I have, Lordship, 7 matters which I can give is not called your.
Let us see, Mr. Yes, let us see. Just wait. Let's see this month. I'm trying my best to pick up these matters. Kindly wait. Yes, madam. Yes,
Lordship, may I be permitted to mention this matter? Your lordship, this matter was heard by your lordship on several dates, and thereafter your lordship had directed to list the matter under for orders on 28th of August. Your lordship, thereafter the determination was changed and it was mentioned several times. It is not appearing.
I'll check up. Yes, call the list.
Just once, Lordship. This is interest matter. Department, the other side had taken instructions. Time to take instructions.
Mention this tomorrow along with those identical matters. Yes. Next. Not tomorrow, means next week. Next Tuesday. I've allowed Mr. Ghosh to mention and Mr. Siddiqui to mention on that date. Otherwise, no mentioning from the monthly list. Monthly list mentioning is closed. Future only for you on that. Otherwise, monthly list mentioning is closed. I'll only allow supplementary list mentioning. Otherwise, it will be very difficult. Every week, someone comes and mentions. I have to take up these matters at the end of the day.
Already 12:30.
Yes. Call the list.
Well,
I am for the petition, my lord. For withdrawal, my lord. In this case, on the last occasion, your lordship, my lord, observed that there was a direction for payment of 10% of the tax in dispute whether you paid. There was no such direction. Paragraph 7, my lord.
Lordship, kindly see the lordship's order.
Paragraph 7, my lord.
पूरा पढ़ो ना।
तो क्या ये तो है?
ना,
यही पे लिखा हुआ है। तो यहाँ पे लिखा हुआ है, पढ़िए।
Oh, this has been realized.
Yes.
Mr. Duggal, learned
I'm
advocate,
carrying the
defends
order,
the
similar
petitioner
order.
by placing before this court.
Similar
That
order,
is there.
Similar order, my lord, which your lordship has.
No. I'll just permit you to withdraw. No.
Wait, please, ma'am.
Money square.
My lord.
There's some issue, another writ petition pending there.
My lord, I have challenged a adjudication order which has been passed after around 10 years. In my own case, my lord, this order was passed for another matter. And my lord, several issues on the same issue, several matters are pending. Lord, show cause notice was dated 2013 and adjudication order is passed in 2024.
Show cause is when?
2013.
Correct.
And
correct.
It was sent back to the callback, call book, my lord, for whether sufficient.
That Bombay and Gujarat High Court have actually.
Tell me one thing, Mr. Bhattacharya. I'll not keep it pending. I'll dispose it of today.
No, my lord, what happened? The similar issue in another matter, my lord, kindly see.
No. Just first factually tell me 2 or 3 answers. Is it correct 2013 show cause? Correct. Achha. After the 2013 show cause, was he given further opportunity before deciding the same?
He appeared, he filed written argument.
When?
2014.
Correct. 2014?
And he has also given hearing, my lord. Then the order was passed.
2014? Therefore, between 2014 and 2025, no order was passed.
Ultimately, my lord,
I'll set aside that.
personal hearing given, my lord, on 9 January 2024.
So that we challenged and we replied that we will not participate and then we came here.
Hearing was given to him.
Yes.
Yeah, show cause notice cannot be kept pending for so long.
My lord, similarly.
Well settled, sir.
My lord, can I appreciate, my lord, on the same issue.
Recently, Delhi High Court has given this judgment. It takes into consideration Customs Act, Finance Act 1994 and even the GST legislation.
No, ordinary law does not permit you.
My lord, here, my lord, can I appreciate. Here, though it was on 2013, my lord, it was sent for the call book. Their provision was there in the authority.
For 10 years.
No, my lord, what happened thereafter that, my lord, it has been decided, has to be decided on merit. Then, my lord, they
I'll set it aside. If you are entitled in law, issue a fresh one.
No, my lord, same issue has been, my lord.
If you are entitled in law, issue a fresh one. Same issue, yes, same issue.
Kindly see, same issue, my lord. This order passed by the court and changed and by your lordship, by the order, my lord.
The one I handed over in my own case.
Stay.
No. The affidavit was given, well, direction of affidavit was direction. Kindly see my order, my lord.
I have extended that interim order. That is a different issue.
Yes.
Please tell me, Mr. Bhattacharya, please understand the situation. Show cause was issued when? 2013?
Yes.
Achha, he was given opportunity to respond in 2013?
No.
Naturally.
No. He was given responded in 2015. Then, my lord, 2024 also. 9 January 24, he was given 10 January 1924, my lord.
Show me.
My lord, kindly come to page 46.
Show cause.
Show cause at page 27.
You place your case.
My lord, show cause at page 27. My lord will kindly mark the date.
Your response?
Lord, then my lord will kindly see page 34.
This is on send-back credit.
This is service tax and send-back credit. Lord, page 34 is the personal hearing notice asking me after 10 years to appear in January 24.
You appeared.
My lord, I have given my reply objecting to adjudication in the very next page at page 35. I have cited all the authoritative pronouncements.
Not necessary, yes.
And my lord, kindly see my at para 9 at page 38. Well, then page 40, the impugned order starts. Well, I am just drawing my lord's kind attention to the relevant portion which deals with all these facts. But kindly come to page 48. Internal page 7 of the impugned order. Discussions and findings.
Yes.
My lord will kindly see para 5.1.5. Last three lines. Similar case was pending in the EPS code, therefore it was transferred to the call book. 1.1. Last three lines.
1.1.
At page 48, last three lines.
Yes.
Then my lord will kindly take page 51, para 5.1.9. At page 51, para 5.1.7, he reiterates my reply which I had showed to my lord, objecting after 10 years. Then at para 5.1.9, my lord, he records, in 2013, I had replied in 2014. Then my lord will kindly see the next page, para 5.1.11. Very important, my lord.
Yes.
Since a similar case to the instant one was lying pending before the Honorable Supreme Court, therefore a reasonable period is required to be determined considering the call book procedure. The adjudication proceeding was resumed immediately after finding that the matter was no longer required to be kept.
Yes, Mr. Bhattacharya.
My lord, kindly cease, my lord.
You would like to file affidavit, Mr. Bhattacharya?
My lord. The similar issue, my lord.
Ashok. Challenging the No, this can. This
was
is a different
exchange-
issue. This is a different issue.
My lord, no, same issue. Exactly same issue, my lord. My lord, one thing more, my lord, before Supreme Court, this issue was still pending.
Which matter? Which matter? Before the Supreme Court?
Supreme Court regarding this.
Which matter?
The period of limitation.
Which matter? Supreme Court, which matter? Pending before the Supreme Court?
That
Not aware.
Not with.
When it was transferred to the call book?
But it was transferred to
When? Date.
But it was, my lord, 2013, my lord. 13.
Yes, tell me the date when it was transferred to the call book.
And the para is common
Their own board circular requires them to intimate me if they are transferring to call book.
Why will the court not accept it that is show cause reply to the show cause was appropriate for which this proceedings was dropped? Why will not this court not presume after so many years you are saying similar matter? Which matter?
Regarding
similar issue, which issue?
Section 74, my if your lord.
Section 73, 74, there are so many facets.
No, Finance Act says, my lord, within a period of 1 year, if it is possible, my lord, kindly appreciate here, my lord.
I am not going that far. Today you are after 3 years and 5 years maximum. Today you are after 25 years. You can't come and do this. Actually, 15 years. 15 years.
24.
Before that, 3 years had gone. Before issuance of the notice, 3 years had gone. So 2013 is before 10. Today we are in there 25. 15 years.
Now, my lord, kindly appreciate, my lord, in the order original, he participated in 2024 hearing. Kindly appreciate, my lord. Your lordship is perfectly
He
correct.
did not participate. He
Yes.
raised this question.
No, you kindly cease, my lord. Kindly cease, my lord.
Yes.
4.5, my lord.
Yes.
4 point, my lord.
He gives this answer.
My reply is at page 35.
I've seen his reply. He filed an affidavit to this. Mr. Bhattacharya, no point arguing this.
My lord,
matter.
kindly cease, my lord. 3.04.
Yes.
46, kindly page 36, my lord.
Personal hearing was given to him. Very well, I've seen that.
Personal hearing on 9/1/2024.
Yes, very well. I'm so happy to hear that.
Therefore, my lord, in 2024,
present
hearing was
You disclose all records, Mr. Bhattacharya, disclose all records, including the call book.
I'll deal
You have to, you understand, you have to. That is the only way out. If you can demonstrate that you had kept him informed, he was well aware, then his case falls.
So he has to also demonstrate what happened, which matter got disposed of in the Supreme
Yes,
Court.
that particular has
Yes.
not been
that
recorded.
particular, we shall collect, Bello, we shall collect that. I think not that matter.
So why he
Some-
has taken it
yes.
out of the call
some
book, that also
judgment
he has to
against
say.
us, I know, my lord, some judgment passed by the another High Court, my lord, against us. But
I'm not gone there. I've also not gone by, that is why I've not gone by the coordinate bench judgment, because that did not decide anything.
my lord, call book procedure originally was there. My lord. It is not that
Show me,
I
show
will
me,
I'll
show me.
show it.
I've given you opportunity. Yes.
I'm grateful.
এটা কেন কেসটা কেন কি ব্যাপারে?
তিন চার দুটোই তিন চার
Yes.
The petitioner is willing to further.
Oh, you wanted to take instructions in this matter.
But normal reference says the one they wants to withdraw the writ petition.
They have already paid taxes for availing the waiver scheme. Here is my instruction.
Because prima facie this case, you could not have passed this order, proceeded.
No, my lord, we could have, my lord. I would have made submission with regard to this. But now since he wishes to withdraw, my lord,
Nothing here. You are Mr.
Shumon Bhumi.
Mr. Bhom. দুটো লেটার আছে ওটাতে 4 and 5 একটা কমন লেটার ঠিক আছে থাক একটাই হবে
next. 5 আমাদের
call the next matter.
For the petition, I am assuming here in the appellate authority's order. I have the appellate authority.
affidavit here.
Where is the appellate authority's order?
Page 126.
126 on.
22nd October 2024.
Your lordships may come to operative portion, that is 127, observation of the appellate authority.
On merits, it has been dismissed.
Lordship, unreasoned order, your lordships may find the last third line, your lordship. May I place your lordship?
Some reasons are there, observations by the appellate. Yes,
I was
what is order under section 73, 74? What
73, your lordship.
Challenging the order.
Grateful, Your Lordship.
My lord, 6 and 7, my lord, I am being led by Mr. Harish. Appearing.
May I please, Your Lordship? May I please, Your Lordship? Your Lordship, these writ petitions are filed challenging the orders in appeal. Not getting the point?
No, it's resounding a bit.
This is better, my lord.
No, I can't hear you.
My lord, the writ petitions that have been filed are challenging two orders in appeal, identical orders in appeal. The writ petitions have been filed on the ground that the orders in appeal travel beyond the reasons that have been provided for in the show cause notice for rejecting the refund claim.
Hey, silence, please. Silence. Silence, please. Yes, sir.
Your Lordship, the writ petitions.
बढ़िए दाओ ना, volume to बढ़िए दाओ.
You're not able to hear me now? What's it? Is this better, Lord?
Sorry for interjection, my lord, to cut short. I think the state is the answering respondent, but my lord, they have served directly upon the authorities. Because
I'll
state
serve
is
the
not
copy
being
upon
treated.
the.
So if a copy can be served, my lord, we can submit. Copy can be served.
Yes. Right now, my lord, I can give him the copy if required.
Your Lordship.
Yes. Upon the, we have served directly upon the respondent.
My lord, not served on the GP office, my lord.
Right. My lord, I'm serving right now. Serve right now. My lord, I've served it right now, my lord. That may be Pooja Shah, my lord. Pooja Shah. Both the
Stuck upon the state council.
My lord, if any date may be fixed because he will be traveling. Next week, Monday?
The holiday.
Next Monday is a highlight.
It's the holiday. Monday to
Monday,
Tuesday.
Oblige, Your Lordship. I'll appear in person, Your Lordship.
Whenever. Next week. No, you don't need to appear on. Only clarity is necessary.
I'm faithfully.
Your choice. If you want to come down, you
My lord,
always.
it's better than my lord if he is here.
There is something.
I'll be physically present, Your Lordship. My sincere apologies.
Can it be on 22nd?
You want that particular week, third week.
22nd, my lord, is
22nd, we have appeals with before the honorable.
okay. 23rd.
Second is up, right?
23rd.
Tuesday, 23rd.
23rd, my lord.
You see, this will be taken up in the monthly list only. So let it remain in the next week. It will be always better for you.
Okay, my lord. Let it be.
So the Shah's she has already made over copies of the writ petition. She has already made over copies of the writ petitions to Mr. Siddiqui, who is present in Mr. Siddiqui, learned additional government pleader and senior advocate who is present in court.
Much obliged.
Your Lordship, the matter will be taken up on Tuesday, Lordship, on 15th.
Be there from Monday onwards, whenever it is there. Monday, Tuesday, we have holidays, so from Wednesday it will be taken up.
Oblige.
Much obliged.
Let this matter be taken up for
Next
consideration.
next Wednesday, my lord, I have some personal difficulty, my lord.
Thursday. Let
Let
this
it be on
matter be taken up for further consideration under
on
the
Thursday.
same heading. Thursday means Thursday means, madam, second half.
No issue, my
Oh,
lord.
so second half.
Then on 21st, 22nd.
Yes, I think it will be better. She has some difficulty.
23rd is better, my lord.
Your
23rd.
Lordship, 23rd, I'm Lordship, and before the Delhi High Court on 23rd, if it could be 21st, 21st, Your Lordship's fine.
21st.
Likely 21st it will be taken up because first half, if I first half the urgent matters are there, second half this matter will be called fairly at the top. If item number 1 in the monthly list. Yes, call the next matter.
So, like, Lordship.
The 21st. 21st. Next. Daku. Madam, affidavit of service you have filed. Filed. Opore affidavit. একটা অর্ডার করে দাও একটা অর্ডার করে দাও these madam, these are identical matters, madam. These are identical matters. One common order.
One
I'll
common
hear
order.
it
My lord,
together.
one correction need to be made in the second.
Oh, তাহলে আলাদা order করে দাও আলাদা
No, my lord, the cost title is printed wrong. It be separate orders, my lord. I understand. Let it be separate orders, my lord. But the cost written as REDX instead of FedEx. The print.
Leave granted. Which matter? Which matter?
My lord, my cost title is correct. The printed cost title, which is
list.
in the list. The second
last
one.
time, the department is directed to which matter? Which matter? Both matters.
7. Only the item number 7. 6 is
Department
okay.
is directed to
Both are FedEx, my lord, not
FedEx.
REDX.
Both are FedEx.
Both are FedEx.
REDX is not correct.
Directed to publish the cost list. No, it can't be corrected now. This is a monthly list.
Yes.
So not necessary. Can't be corrected now.
I'll just,
হবে না correction.
when it is appearing in the daily list, my lord, that
It will not appear in the daily list. It will be there in the monthly list only. Yes, call the next matter.
It has become red.
But
Cost title will not make a difference, madam. In the list, it will not make a
But
difference.
REDX shouldn't be staying, my lord. REDX is not correct, my lord. FedEx should be there, my lord.
File FedEx, yes. Separate orders. Yes, call the list. Call the list.
I am appearing, Lordship, on behalf of the petitioner, Lordship. It is a service tax matter, and today I am addressing your Lordship not on the merit of the matter, because I have come before your Lordship on the ground of violation of the principles of natural justice. In 13/12/2016, adjudication order was passed. I made an appeal against
You
the
are challenging the adjudication order of 13/12/16 now, or prefer an appeal?
No, adjudication was passed in the year 2016.
Thereafter, what happened?
Thereafter, I filed an appeal. Appeal was disposed of on 22nd May 2018, and it was remanded back to the adjudicating authority on the ground of violation of the natural justice.
Then what happened?
Thereafter, notice was served upon me in the year 2023 for participate in the adjudication process. But 5 notices were served, and all the notices were served after the date fixed for hearing. So I could not participate.
All notices?
All notices. And it has been observed in the order also.
Thereafter, you prefer appeal once again?
As per the adjudicating authority, the 6th and 7th notice was served upon me, but that notices was not reached at my office.
Mr. Banerjee, is it correct?
Lordship, can you come to page 139?
No, you must have checked out.
139?
139.
Have satisfied yourself. I'll take it from you. You have satisfied yourself that he was served. He comes up and makes a statement in court. He has not been served. And not once. He says 6 notices were not served after the date.
Because document says it's something different, but I will again take instruction from the
Yes,
department
yes.
to that extent.
Because you see, then what is the use of giving a notice?
I will see the track of each notice.
Correct. You satisfy yourself, you come. Mr. Roy Chaudhary, you also ensure this. So you're not concerned. So that you kindly check this, because you see, if it has not been served at all, then no point.
5 notices were served.
No, I will not. What I will do is I'll permit him to appear only. Nothing more.
I will.
No, not today. Tomorrow.
Lordship, kindly not take it tomorrow. Because
Not this week. Not this week. Not this week.
Yes.
Whenever it is taken up, not this week.
Sir, immediately.
Having regard to the allegations, having regard to the nature of allegations, having regard to the nature of allegations made in the petition, the
Affidavit of service may be kept.
affidavit of service filed in court is taken on record. Next. Off noise, 17th April, 17th April 2025. 17. Next.
For the respondent number 2, my lord, Union of India. Answering respondent is a GST, my lord.
Well, for the statement.
Yes.
The statement.
আজকের দিনটা not today.
It's a challenge to a order passed by the appellate authority.
First day, they are not there. First day, they are not there. I'll make it not today. Next day, they are not there to go out of the list. I'm not dismissing now because it does not really help.
No, my lord. Another application.
Yes.
I appear. My lord, here I am challenging the adjudication order on the ground of various illegalities. My lord, first one, my lord, the
Who is appearing for the respondents? Adjudication order under
CGST. My lord, under
Yes.
section 73, my lord.
Adjudication order you are challenging. Yes.
73.
Violation of principles of natural justice. No.
No, my lord.
On merit you are challenging.
Yes, on merit and other illegalities are there, my lord. First one, my lord, the summary statement of show cause notice has not been given in form GST DRC 01, which is mandatory under the GST law. Under rule 142, that is mandatory. That has not been served.
You had been served with the show cause? When you received the show cause, did you take this point?
But I have taken this point in the petition, but
no, sorry, I will not permit you to do that.
I have received the detailed show cause notice, but not the summary of show cause notice.
I'll record your submissions, but I'll not permit you.
Next one, my lord.
Next point.
Next one, my lord. This adjudication order is time-barred order. It has been issued beyond the period of limitation.
Show me.
My lord, how, my lord? My lord.
Someone. Yes,
Lord, kindly-
madam, come here. Yes. So someone has to appear.
My lord,
Yes,
kindly
next.
come to page 40, my lord.
40.
Yes, my lord.
First the show cause. My
lord, show cause at
page 19.
Show yes, 19, my lord.
And your which page is the order?
Order is at my lord,
Madam,
page
kindly give
25.
her a copy.
Page 25, my lord.
What are you waiting for?
Page 25.
Yes.
Well, can you see the order was passed on 19/12/2023. Page 25.
Yes.
And my lord, if your lordship kindly come to the notification given
The notification will come later. Show cause is in respect of which period?
my lord, 1819, 1718 and 1819.
at 1718
and 1819.
30th October, madam. 30th October is the date? Or 13th October? 30th October.
Show cause was issued on 31st August.
No. Returns are to be filed by 30th October? 30th October. So 3 years from 30th October. 2017-18.
No, my lord, it was extended. It was extended till 7th February 2020. As per the notification given at page 40.
Page 40?
The notification given, my lord.
Yes.
40.
Yes.
As per this notification, my lord, the date for filing annual return was extended till 7th February 2020.
Yes.
Therefore, my lord, under section 73(10), the last date of passing the order was
7th February 2023.
The combined notice.
Yes, for different states, my lord.
So far as the notice
1780 is concerned, my lord, it is time barred.
78 is time barred. The others are not.
Not 1880. But if my lord, one part of the order is time barred, then my lord,
I'll
the whole-
permit them to pass a fresh order immediately here and now.
Yes.
1718 goes, madam. I set aside. Take. Will you take? Yes, tomorrow only, because you see, everything cannot go. 1718 goes, I'll set it aside here and now and permit you to pass a fresh order. I will extend the time. Permit you to pass, because everything cannot go. And I'll not permit him to challenge everything here. So this part is, to the extent whichever is rotten, let us segregate that. And you can proceed, take instructions. Since a jurisdictional issue has been raised as regards,
And my lord,
since a jurisdictional issue has been raised,
kindly 1 minute. Well, so far the 1819 is concerned, my lord, I have challenged this on the ground that my ITC has been disallowed only on the ground of disparity between.
that I will disallow here and now. I'll record it here and now. You want me to record it here and now?
No, my lord, disallow means.
Don't. So wait. Let her bring instruction.
My lord.
The Madam, bring that instruction on that date.
Written instruction.
I'll just segregate that part.
No, written instruction with that respect.
Everything will not go because I have seen the show cause is very clear, distinct. But the order has to go. The order is a composite one. I can't segregate the order. So take instructions. If it is possible, then I'll permit you to pass a fresh order with otherwise rest is concerned. Because he cannot maintain the entire challenge before this court. Try your luck on the next day. Yes. But you see, I am not that I have, this is my view. This is what I propose to take after hearing you. I have not decided this.
Well, I will show on the next.
It's very risky to express yourself because at times the learned advocates feel that I have already decided on the matter. I have not decided on the matter.
Okay.
But my proposed view so that you can respond to that if you wish to.
Well, I will show on the next day.
No, you come on the next
Same
day.
authority has assumed jurisdiction under both CGST Act and both SGST.
And
That cannot be
I
done.
don't know.
I will show on the next day.
Next. I don't know.
I am for the petition. Madam. Now, this is the case pertaining to the period 2018-19. Well, the time to complete the proceeding under section 73 of the GST Act, 168A, extending the time to complete the proceeding. I have challenged those notifications as well as
Same order, Mr. Siddiqui. These are
Covered.
covered matters.
Covered during the interregnum.
Corrections.
but only the name of the advocates appearing on behalf of the state, my lord, should be changed. Other
And rest is okay.
rest is, my lord, I've changed.
Okay.
My lord knows it.
It's not your lordship's order, my lord, it's the coordinate bench.
My lord, now this matter, my lord, is pending before the Honorable Supreme Court.
নামটা শুধু বদলে দেবে মানুষ মুখার্জি বদলে ইউনিয়ন অফ ইন্ডিয়া এনিওয়ান ইজ অ্যাপিয়ারিং নো এটা কেটে দিয়ে না মানে মিস্টার
সার্ভিস করেছে সার্ভিস
আর মিস্টার তনয় চক্রবর্তী WBGST.
WBGST.
Oh, Mr. Rai.
It's already there. Name is there.
1352 হচ্ছে
এখানটা কেটে দিলাম শুধু আছে অদার স্টেট হ্যাঁ ঠিক আছে yes next আচ্ছা
You'll have
থেকে দাও
একটা বাইরে
Darling is so
Your Lordship, I'm appearing for the petition in this matter. Your Lordship, proceeding was conducted against me under Section 73. Thereafter, Your Lordship, the demand order in GST DRC 7 was passed. Your Lordship, thereafter, we had preferred an appeal, and the appeal order was passed on 24th of December 24. Your Lordship, thereafter, due to non-constitution of the tribunal, we had further deposited additional 10% of the disputed amount of tax on 1st of January 2025, Your Lordship. And the same was intimated to the department on 3rd of January, by letter dated 3rd of January 25. Your Lordship, in spite of that, recovery was made from my electronic credit ledger on 9th of January 25.
From the petition, I could not find any document where the recovery has been.
Where is
Your-
the statement? Where is the statement?
Your Lordship, it is there in facts. Your Lordship, actually, there was no recovery notice issued, and the recovery was made.
Stated which paragraph?
Your Lordship, I'll just. Your Lordship, it is in page number 10, paragraph 3.15. May I read, Your Lordship? Your petitioner state that in spite of the undertaking and the payment of 10% of the tax in dispute, the respondent number 1 has proceeded to recover the amount of the remaining tax from the electronic credit ledger of your petitioner in.
Statement I have not followed.
Your Lordship,
Inspection whether they have recovered or not. Now my learned friend comes up with this electronic credit ledger.
No, it is not part of this disclosure.
No.
Your Lordship.
I was just checking the.
Your Lordship, it was a part of the intimation letter. Your Lordship, it was just missed to be annexed to the writ petition.
Supplementary affidavit enclosed. You take instructions. I'll grant a leave to file.
Because if it has been recovered, well, it has to be refunded back.
Where is the intimation?
Your Lordship, it is at page number 75. Your Lordship, the proof of pre-deposit was also attached to the intimation letter, which is at page number 77. And further, Your Lordship, the amount which was deducted is a part of the letter here. Your Lordship, in the second page, there is a table. Serial number 4, Your Lordship.
77, what have you annexed?
77, Your Lordship, it was the pre-deposit made by us for additional 10%. Thereafter, Your Lordship, the document that I have submitted just serial number 4, Your Lordship, dated 9th of January 25, under the central tax column, 342 was debited. And in the next page for the state GST, in the next page, Your Lordship, at serial number 5, 49,988 was deducted.
Serial number?
Serial number 5, Your Lordship. In the third page. Second page is for CGST, and the third page is for the state GST, Your Lordship.
So they have not deducted anything. CGST has not deducted.
CGST has deducted rupees 342.
Who's appearing for CGST?
Your Lordship, the state is the answering respondent. Both.
You have deducted.
If at all, it is deducted both by the state for both CGST and
SGST. And in the next page.
For first, second page, where have you deducted?
In the first page, Your Lordship, 342, column serial number 4 from cash ledger. And in the next page, Your Lordship, serial number 5 from ITC under the SGST head. Rupees 49,980.
Cash ledgers. Type of transaction CR. CR means?
Credited, Your Lordship. It was credited from my ledger. It was deducted, Your Lordship.
Ledger discharging liabilities cash.
Yes, it was debited from my cash ledger.
And the next page is?
Next page is ITC, Your Lordship, serial number 5. It was debited from my electronic credit ledger, rupees 49,988.
342 and 49,000.
Yes, Your Lordship. In total, it is 50,330 rupees.
I'll pass an order. If it has been done, you refund it. No point in taking it because there's so many matters are pending. You will again come back. But have you challenged the order here?
Your Lordship, we have challenged the recovery proceedings. And Your Lordship, if the 3 months were not, 3 months had not expired also. Not expired. No, no, Your Lordship.
Undertaking as and when the tribunal is constituted, we will prefer an appeal for that.
Your Lordship.
I have decided in one of these matters that prohibition can be granted or not. So, no deed of prohibition can be allowed.
Yes, your lordship, I keep forgetting the name. And Mr. Amitesh Banerjee was also appearing in that matter. Your lordship had passed that prohibition will not apply.
Set aside.
No. That was a different. You are saying.
The Modern Court Charge appeal was subject to correction.
Yes.
And that matter, my lord, was set aside by the Honorable Division Bench.
That was not on the point of prohibition, Mr. Siddiqui. It was on the merits of the case. Prohibition cannot be granted. That was the finding of this Honorable Court.
I was whether you can be entitled to prohibition or that was for prohibition.
Prohibition.
You have the judgment, both the judgments.
I'll come with it.
Very well. Show me the judgments tomorrow. So far as this part is concerned, I am making it returnable up with the direction. Because 3 months have not yet lapsed.
Your Lordship.
3 months have not lapsed.
Not lapsed.
Challenging an order passed by the proper officer.
The appeal order. We have just challenged the recovery.
Challenging an order Not necessary for me to record this.
Any technical difficulty, I'll come back.
And not necessary for me to record this second
Your
part. ওইটা কেটে দাও।
Some interest.
And what happened to that on that issue of that portion has been set aside? If you can we show me that? Yes, yes. Just give me that.
Worship, this 3 months interest, they will pay us.
I'll give you a check.
349 rupees and
For 50,000.
ওটা দাও তো। Yes, এটা একটু করে দাও, আমাকে প্রিন্ট করে দিয়ে দিও, আমি দেখব। Yes, call the next man.
Grateful to
ওটা
your lordship.
এটা ওকে দাও না, পাঠিয়ে দেবে। আরে তুমি নিচ্ছ কেন? ওকে দাও, পাঠিয়ে দেবে। তুমি লিখে নাও, লিখে নাও। Both the WP number as also the division bench order, Mr. Siddiqui. Both the
I have the division bench order.
very well. আমাকে দিয়ে দাও না, আমাকে দাও। কি কল করো? কি আছে? কি হলো? কি হলো? আচ্ছা।
13, my lord, I am appearing, my lord. My lord, what has happened? My lord, what has happened, my lord? Inadvertently, my lord, I have made CGST also a party because herein I am challenging the show cause notice issued by the state GST, my lord, saying that already the issue has already been adjudicated by the CGST authorities. So, my lord, inadvertently, I have not served the copies to the
Copy
my
should
lord.
be served
And
upon
my
the-
lord, my lord,
The copy of the writ petition.
my lord, may I, my lord?
The party.
No, I have made a party, my lord. I have not served, my lord. My lord, supplementary affidavit is required, my lord, because at that point of time when I filed this writ petition, adjudication before the CGST was pending. That was subsequently completed, my lord. The final order.
Leave
was-
granted to file supplementary affidavit in course of the day. Leave granted to the petitioner to file supplementary affidavit in course of the day. Full stop. Let a copy of the petition along with the supplementary affidavit be served on the CGST authority.
Yes, my lord. I have made a party, my lord. I have not.
Affidavit of service.
This is only served to the state authority. Because the issue has already been decided by the CGST authority.
भाई जाओ, copy तो नहीं।
You are serving here and now.
I'm serving the soft copy I can serve and hard copies I can.
Hard copy mal rahe, hard copy में भी।
Both are boys.
Let affidavit of
Soft
service be filed on the returnable date,
Yeah.
demonstrating service on the CGST authorities.
My lord, next week, my lord.
Let them serve to me, my lord.
Let কি বললাম? Let next date, on the next date when the matter is taken up to demonstrate service on the CGST authorities. Please let this matter be taken up paragraph. Let this matter be
Well,
taken up for
instead
further
of
consideration under the same heading on 21st.
Well, instead of CGST authority, copy should be given to us.
21st.
To us, my lord, we shall take the instruction from the department.
I shall definitely today by itself. I will get it.
Can you record that, my lord, so that I can, my lord?
He'll serve. File an affidavit of service.
No, we have been instructed to appear. my
আচ্ছা
lord.
কি আছে বলো? Let a copy ওপরে let a copy of the petition be served on Mr. Bhattacharya, learned advocate, post সঙ্গে আগে served on Mr. Bhattacharya, learned advocate representing the CGST authorities.
Mr. Papan Mohanjo, junior, my lord.
হ্যাঁ ভঞ্জ করে দেবে করে দেবে। তুমি লিখে দাও করে মিস্টার ভঞ্জ করে দেবে। Upon Mr. Bhattacharya, learned advocate representing the CGST representing
I have given you hard copies.
Yes, next ডাকো হ্যাঁ ডাকো next ডাকো।
Well, I am for the petitioner, my lord.
Right, please, your lordship.
My lord is dictating something.
Mr. Siddiqui, this is passed by this court.
Yes.
No single bench order. Yes, yes.
Prohibition among that.
Yes, next.
Matlab there is an assessment order passed in 21st of December 2019 under section 147, so read with 143.3, my lord. Then, my lord, they have initiated the recovery proceeding. Then we came to know that the assessment order has been passed. Then we preferred an appeal in the month of in 2020, my lord. Then, my lord, we prefer appeal paper has been prepared. Then, my lord, we have intimated the authority concerned to hear out our matter. Then, my lord, on 2023, our High Court has passed the order. May I place this order, my lord, to fix the matter for early hearing? Kindly come to page 31 of the writ petition.
So what happened thereafter?
Thereafter, my lord, we have intimated the authority council repeatedly. They have not done anything. This is the order passed by our High Court on 13 January 2023, page 31. They have, then we have
Even after that, nothing has happened.
nothing, my lord.
Must have been, because my lord,
My lord,
it's
till
also
date,
surprising why even after
even then,
communicating
90% has been
instructions of
recovered.
this court, there should be,
Demanded
my lord,
amount.
expeditious steps should be taken, my lord, to dispose of that. I cannot, my
The
lord,
specific
approve of
order
this.
has been passed by this High Court, my lord, page 31. And then we have intimated in the next page 32
Who
on
is CID
18.
appeals now?
Yes, my lord, direct them, my lord.
No repeated directions.
I understand, but this is
Now explanation.
I understand. This is also embarrassing for me, my lord, because
No,
they are
now
so
explanation. No, I will not repeatedly direct. Person is not adhering to the High Court's order. File an affidavit and explain.
Let me come back, because I also, my lord, need to know what was the reason for which, my lord, even communicating this order, my lord, no step. Let me also ascertain whether there was any steps taken to, my lord, get it expedite or not. That should be there. Something must have been done from that end. Something
That
must
is
have
on
been done.
January
Let's be very candid.
13 January 2023. Today 2025,
He has
April
to file an
2025.
explanation. Let him file an
Yes,
affidavit.
my lord. Yes. Well, a short period of time.
Now he will be called upon to, in addition to the discharge of his obligations to decide matters, he will now have to file affidavits before courts.
That
So
is,
consider how the situation will be difficult for him. He has to decide matters. Now instead of deciding matters, he has to file affidavits before court.
that will be, my lord, falling very, hard on him.
No,
But
no,
I
no.
believe-
No, certainly not. Why will it be hard on him?
But
Waiting since 13 January 2023.
there might be some. I
More
do
than
not
2
know-
years have passed.
I do not know, my lord, what might be the reason for which, my lord, it was not expedite, because of the fact of there was a directions of this court. It must have been communicated, and he must be taken note of this. He must have been given some priority to this appeal, because this is
The
pending.
communication
So I
is through
cannot-
portal. We have through portal, my lord, kindly see page 33. We have intimated on 7th November 2023. Then, my lord, again on 8th of December 2023. Again, my lord, we have intimated page on 11th March
Mr.
2024.
Mojumdar, learned advocate representing the petitioner, লেখো অন্যদিকে তাকিও না, এদিকে তাকিয়ে থাকো।
My lord, I'm appearing for the petitioner. This
Yes,
is
yes.
5 matter, my lord. The My lord, this is the 16th amendment, which
আমাদের একটা copy
chart is at page.
So this point was not decided, Mr. Siddiqui. No, this point was not decided.
Writ of prohibition was not decided, my lord. As a matter of fact, your judgment was not touched. It was only on the change of the merits of the case. They said that I will not be canvass. Now, that's why I pointed it out to your lordship.
That is something that my lord, because my lord was to the position that therefore Sashuraya was not.
Because I have recorded that. Anyway, neither. No, I wanted to know that what was the decision on the point of whether without only prohibition was maintainable. So that decision.
No, they went up and said they're not going to canvass the merits. They just said we'll just file it. Well, they did, in appeal, they did not canvass the merits. If your lordship sees the judgment, they just went up and said that we'll prefer the appeal before the tribunal. On that, the consideration was passed. So, my lord, your lordship's judgment stands, my lord.
Oh, no. One line is there that this writ petition is maintainable. So in that case, that line is there. I had seen that line. That line is there. Writ petition is maintainable. Hence, considering the nature of case brought forth by the appellant before this court, where a prayer sought for writ petition is maintainable. Prayer is maintainable. Also, but that is in having regard to paragraph 6 only, Mr. Rai.
Yes, my lord.
You see, paragraph 6 only. That finding is.
That's why molding the prayers, my lord, he makes the writ petition maintainable, my lord.
Anyway, very well.
That's why I said, my lord.
It's always best to keep yourself updated on what has been decided.
Not only that, my lord, it's a close matter to my heart, my lord. I wanted to argue this in so many places. I argued it before your lordship, my lord. So, my lord, I would not let it go.
Yes.
My lord.
My lord,
Yes,
this is the 16.5 matter, my lord. The amendment has been in the state notification in page 3, my lord.
What
Earlier it was
remains? You decide this.
You'll also kindly pause ministry order, will decide.
Because no point in the court deciding this. Amendment is there unless you want to say something else. Yes.
because earlier
16.5 it has been amended, lordship. Therefore, it has to be tested in that line only.
So I'll set aside.
No, lordship kindly demands it back. We'll see to it, lordship.
set aside.
I have to set it aside and remand it. Otherwise, what will I do? Mr. Dey, you tell me. You argue the matter. I'm not stopping you. You want to take instructions? You want to take instructions? Not today only. Take instructions and come back. Not today only. Only not today. Come back tomorrow. Next
In that case, the lordship kindly directs us to file de novo order in this matter, considering the changed circumstances.
Tomorrow. Consider it. Because I have to set aside this. I cannot retain this order.
Very good.
ডাকো তিনটে অব্দি ডাকো 2:45 আছে আমি জানি কেন অরিজিনাল সেটে পুরো চলবে এখন আজকে পুরো দেওয়া আছে
For the Union of India. Item number.
And for the
yes.
My lord, I have come up against recovery proceedings pursuant to orders passed under service tax. But I have raised.
In this matter, my lord, we have instruction to appear, but we have not received the copy. So if your lordship kindly takes up the matter next week, my lord.
Since Mr. Dey, learned advocate, representing the respondent PGST authorities. Respondent, Mr. Dey. Who is appearing?
No, I'm mistaken, my lord. Miss Manoj Mukherjee is appearing.
Today?
Dada is in 15.
You got received the petition? No.
Only not today.
Have you received the petition?
Petition, yes.
Not today then. She asked for not today. Very well. Not today. Next, Dako.
My lord,
The notice of assessment served upon me was on the additional tab, my lord. And there was a delay of 47 days, my lord.
So those additional tap points are over, Mr.
My
When
lord,
was the order passed?
My lord, 24, my lord. I had filed an appeal against this, my lord.
File an appeal?
Yes.
Coming from an appellate order?
Yes, yes.
Where is the appeal?
My lord, page number.
You're challenging the appellate order?
My lord, in the appeal.
Are you challenging the appellate
My
order?
lord, my lord. My lord, 87, 57, 88, 58, my lord.
I've seen that. Are you challenging the appellate order?
My lord. And
The
if
appeal
lordship
was
comes down to
rejected
page
on
number
the ground
52,
of delay, and set it aside and send it back.
my lord.
Tribunal is yet to be constituted, you see.
Kindly appreciate, my lord, it was not, my lord, before the appellate authority. They never said that these notices were approved.
My lord, my lord, lordship comes down to
I am not going into that issue.
Said that they were looking for a proper consultant, they could not.
my lord, page number 52, my lord, page.
You decide on merits. Only thing you decide on merits.
My lord.
Today there is no tribunal, Mr. Siddiqui. That's the difficulty.
But still, my lord, the law is, my lord, well settled, subject to question. Even SK Chakraborty's judgment. But not with regard to this.
No, I understand.
I'm not against him. No, my lord, the law is.
My lord, I am
not with regard to
Mr. Choraria, kindly wait. He's not against you.
One was given this particular application.
Yes, yes.
My lord, in this particular case, there is an application for condemnation of delay. The appellate authority takes into consideration that application, sees what are the reasons for delay. He says, my lord, he was looking for a consultant. That consultant was not available. My lord, the appellate authority takes into consideration that this is the people ground because you had participated in the initial stage and thereafter was pleased to dismiss the appeal. But I'm not into this matter. This is hardly a delay for 20 days. But my lord, each and every case, my lord, subject to question by my lord.
So long as the tribunal is not there, then the High Court will have to decide, Mr. Siddiqui. Today, the grounds are different now. Now the grounds are different, one which I am sending it back. Because the High Court will have to decide this.
Trying to impress my lordship, my lord. Now, my lord, my officers are not going beyond the judgment passed in SK Chakraborty's case.
I know that. I'm not, that's why now that's come a long way. So,
I'm sorry to differ
order dated, challenging the order dated 3rd January 2025, passed by the Huh? He? Bank attachment. Yes, having regard to the fact that the petitioner has already deposited the any urgent matters after this? Audience side. Audience side, audience side. 245 তো original side আছে 245 আছে I'll permit you to mention this matter after the 245 matter is over. না মেনশন দিচ্ছি না দেখে দাও Just a minute. You have to now the letter has been produced by Mr. Pragyan Sharma on the last occasion. No, have you received that letter? Have you received that letter? No, have you received that letter or not? As simple as that. That letter. What is the issue involved, sir? Unless they say that it is confidential, he cannot hold back. The DA cannot hold back. But if they say that this is confidential, then the DA can hold back. By that letter, Mr. Sharma wanted to make out a case that they have indicated to the DA that this is a confidential information and therefore DA cannot disclose this. এই দিয়ে দাও তো এটা দেখতে ওকে দাও না ওকে দাও you have got a copy of this letter. Mr. Sharma handed over this to you. So yes,
we have handed it over, Malad. We have handed it over.
You take instruction. No, that is Mr. Mukherjee's contention. You take instructions on that, first of all.
What is the instruction?
First of all, you take instructions. If necessary, I'll call for that record from you, whether you have it or not. You already have it. You have the record with you.
I have to
What reply you have? No, that's your internal communication. দেখি কি বলছো? এই চিঠিটা দাও, চিঠিটা দাও।
ওটা প্রতিনিধি।
It's not very clear on this. It says you have received this, whether this is with you. It says they responded to the Indian such and such and produced whatever is there. I'm not placing it very well, not necessary. It may be confidential. The letter is with you. Yes, this 7th February letter is with you. Very well. Yes, Mr. Mitro.
There's just one request, because that letter was handed up. Can a non-confidential version of that letter be handed over to us?
No, Mr. Sharma wanted to hand over the letter to you itself.
The letter is there. What has been just handed up to you, to my lords?
Not at this stage.
Very well, so I just.
But I'm not relying on that document. I've retained it. I'll give you back. I'm not relying on this document.
Very well.
I'll be requiring them to produce the original if necessary from their custody.
Very well.
Yes. I cannot disclose this information to you.
Of course, sir. We have no idea.
So I have not disclosed that information.
Very well.
True, my lord.
If necessary, I'll call for the original letter from their end.
Yes. As I said, my lord, we encourage that, my lord. We have nothing to hide, my lord. Our hands are absolutely clean.
Sharma, today, that affidavit will be subject to an inquiry.
Yes. So why waste time?
Matter will end there.
Yes.
Yes.
What follows from Jindal polyfilm are two consequences. One is writ petition is premature, only a mere recommendation, which is not justiciable, judicially reviewable. That is Jindal polyfilm's judgment. The other consequence of that is that no loss has been suffered by them as yet. They may suffer a loss in future. The members of the petitioner number 1 may suffer a loss in future.
Stable kore dao. Yes. Stable kore dao.
If the final determination is accepted and on that basis some duty is levied, anti-dumping duty is levied by the government.
Yes.
So today, my lord,
that is Jindal polyfilm.
This takes me to the jurisdiction point. Briefly, lordship, the initiation of the investigation or of the proceeding starts by way of Rule 5 notification. That has happened in Delhi.
Cause of action. According to you, part cause of action has not arisen within the jurisdiction of this court.
No part. If there was a duty imposed and some
aspect of that is not felt within jurisdiction, Mr.
If there is a duty, if there is a duty, like if there is a
Mr. Sharma has not argued.
No, but Sharma has. This is a point.
Your point. Very well.
But the section, the Rule 5 initiation of investigation is in Delhi. Notice to interested persons is in Delhi because the petitioner, all notices petitioner has received is in Delhi. Through their law firm, it's been annexed. That is Rule 6.4, notice to interested parties. And the petitioner's representation or information, as one would call it, is given from Delhi to Delhi. Hearing in Delhi. Disclose that essential facts disclosure statement in Delhi notification. Final determination takes effect by way of notification also in Delhi.
No, it takes effect in Delhi, but
No need to be
effect is
served.
not limited to Delhi, jurisdiction of Delhi.
My lord.
Effect is not only felt in Delhi, but effect is felt elsewhere.
Once the duty is levied, apropos that recommendation, there can be a cause of action arising.
That is with regard to the premature aspect of the
Well,
matter.
on the territorial part also, Lordship. On the territorial part also, like this is not a statute which imposes some tax which is under challenge or duty which is under challenge anywhere in the country where a person is suffering the loss by way of having to pay duty. If I have to pay duty in Calcutta, there is no notification published in center under the Excise Act. I may challenge it before your lordship. But if there is no such duty levied, if there is a determination made in
Having regard to the statements made in the writ petition only, not beyond that.
Nothing beyond.
From the
Lordship,
statements made in the petition, you have to show me.
yes.
Because Utpal Basu's case also records that. After saying so many things, it records that we has to go by the statements made in the petition.
Kindly come to page 23 of the writ.
Yes.
For the purpose of jurisdiction, what is the pleading? Page 23, paragraph 27. Your petitioner's registered office falls within the jurisdiction of the Honorable Court. The unlawful actions of the state respondent will cause severe prejudice and financial burden to it. Will cause and not has caused. Many of whom have their registered offices, businesses, and nothing else. Furthermore, if the PUC is subject to anti-dumping duty, the resulting duty will be collected. Will be collected. If it is subjected, then it will be collected. It is like challenging a bill. It is like before it comes into an act. Resulting duty will be collected by customs authorities operating within the jurisdiction. It is submitted accordingly that a part of the cause of action of the incident petition has arisen within the jurisdiction of the Honorable Court. Accordingly, this Honorable Court has clear jurisdiction. This is all. Now, Lordship, apropos this, I will develop on the basis of judgments. First is anti-dumping judgment. Final determination challenged in Madras High Court. Before the recommendation is converted into a duty by way of the government's decision. Whether it is maintainable, then it's only an adjudication by a quasi-judicial authority's adjudication. I may file a case. I may be affected by an adjudication by an authority in Delhi. Quasi-judicial authority. Can I challenge that adjudication in Calcutta? That's the question. Recently, CAT, Alapon Bandyopadhyay was the Supreme Court judgment, transferred the case from Calcutta to Delhi. Delhi Central Administrative Tribunal. It was challenged here before the High Court.
It can't be so open a proposition as that, because you see today a disciplinary proceedings passes an order in Calcutta and the appellate authority is sitting in Delhi.
Then you have the option. Kushumingal. Here's the option. If it is the trial, one authority within one appellate authority house in Delhi, but even both are in Delhi, can you come to Calcutta High Court? Because you happen to be in Calcutta. Now this is not no loss suffered. This is only a quasi-judicial authority's adjudication or no, I would not say adjudicate, final determination.
No, there you don't say that. You say that this is no final adjudication at all. Levy is the final adjudication. When there will be a levy, then there will be a final adjudication. Today, you are far from it. Today, only a recommendation. It is what Mr. Sharma had said.
Right.
Stage of recommendation. You also support that.
Recommendation. So the recommendation is made in Delhi. Hearing before
And he has also distinguished that only a case of rejection, it can be said to be final.
Give me Calcutta one.
Yes, yes.
This final determination, this recommendation is after hearing. After hearing, notes, etc., that is the procedure. This is kind of quasi-judicial recommendation. Before recommendation, people will be heard, affected parties will be heard, and then recommendation made. That's why the word final determination is used. And now,
but the effect of that determination, if it is felt within the jurisdiction, will this court not have jurisdiction to entertain the same?
It's like Soika properties.
Soika properties, it was different. There the tender was perhaps floated and
not tender, there was a property was acquired.
Yes, yes. When tender was the other one.
vesting
Yes,
order
yes, yes.
of a person whose property is losing, property is being lost here. Or ONGC, where a person's tender is rejected.
No, the issue is where acceptance of the tender is the place where cause of action arises. Unlike this one, this is a different matter.
It's a final determination. Like this is more like Soika, where there is a...
They have brought Soika property.
Yes. Urban land ceiling, some 20 or
properties.
So can I give you 1 minute? Soika property.
State of Rice, 1985.
But I will then come to the anti-dumping judgments on jurisdiction come at the final determination.
It is better you show me that.
That first.
Yes.
May I start with that first.
But since you are arguing on this is on cause of action, whether this court has cause of action, you can might and well show that and then move along.
Yes, Lordship, may I show the facts first? And just briefly run through in a minute. Lordship, kindly come to page 55.
Yes.
Page 54, really.
Yes.
Initiation notification in Delhi. New Delhi, that is under Rule 5. Initiation notification.
This is gazetted.
This is gazette. Previous page 54.
Yes.
It kindly comes to...
This is under Rule 5.
Rule 5. J at page 57. Paragraph 25 of this notification.
Submission.
All communications should be sent to the designated authority via email. At the email addresses ADG so it should be ensured that the narrative part of the submission is in searchable PDF form. Then 27, any party interested to participate may register themselves with the designated authority within 40 days. Apropos this, there is a response from
just before you proceed. Where is the registered office of the petitioner?
Of the association.
Association.
Association is within.
Within.
That is the appellate case. So I have to go by the appellate case.
Within.
Hey, cost title take bolo na.
6 Netaji Subhash Road. Yes, yes.
Cost title take bolo.
Yes, within.
No, this is within the jurisdiction.
Yes, within jurisdiction. Netaji Subhash Road. The levy will not be on them again. That will be another issue will be coming up. Levy won't be them, but on their members. That is the locus of an association to challenge.
This is a registered
association, maybe, but then
registered association is competent to maintain a writ petition.
Writ petition, of course, but if it's a case of levy will be the individual in case levy comes. That's second, but that's a different point. Kindly, may I finish this point first? This will take. So this is Page 59 is their response to paragraph 27 of 25 and 27. Page 59. From DSK Legal, Delhi. Kindly see, this is from Delhi. Not that had it been sent from Calcutta would have made no difference, but we represent our client, the Indian Paint Association. So this is their response. I have to go to the merits now. This is followed by a Rule 6.
Response is on behalf of the Indian Paint Association who are based in Calcutta.
Who are based in Calcutta.
So that notification was obviously, publication of the notification was obviously read within jurisdiction and it was felt within jurisdiction for them to respond to Delhi. Otherwise, petitioners are not placed in Delhi.
So the petitioners engaged somebody.
Effect of that initiation was felt in Calcutta.
The initiation,
Can we not say that, Mr. Mitro?
Any interested party can respond. Any interested party, whether in Calcutta, and also Lordship sees paragraph 25, page 57, paragraph 26.
Anyway.
26. The known
Any interested party. So someone who is in Jammu and Kashmir, someone who is in Arunachal Pradesh, someone who is in Gujarat or Maharashtra, and even in the South India, the southernmost part of India can respond. And if they do not choose to respond, they'll be bound by this.
Somebody living, somebody outside India also, the exporting countries, they can also respond. So it can, anybody.
So this is in the form of a publication, means the representative capacity this proceeds to that extent that the petitioners may have initiated an action, but by their action, all and sundry will be bound.
Will be bound. It's like a levy of tax in rem, which every citizen, every entity will be bound.
So therefore, can it not be said that a person sitting in the furthest most part of India will be bound by this action, and therefore the effect of this action will be felt on the furthest most part of India and not limited to the capital or to the place where the action is initiated?
That is, that I will show from judgments will be the levy of the duty. Till the levy happens, now we are at the quasi-judicial final determination. Quasi-judicial final determination takes place in Delhi. It is like my disciplinary proceeding in Delhi regarding an employee based in Calcutta. A disciplinary proceeding who recommends the penalty.
Proceeding that citus
will matter.
Citus will matter. That is different. That perhaps will
not an action in rem, not an action in rem, but this is action in rem.
Yes.
Well, that's why I shall be distinguishing the recommendation, the final determination and the duty. Duty, once it's levied, it will be levied upon Berger Paints, upon the other companies who are members of the association.
Whosoever is infringing will be affected by that.
Entitled to come to court and agitate. But so far as the final determination is concerned, that's a quasi-judicial determination.
Show me judgments on this, Mr. Mitro, it will be better.
Just quickly, Bala Lordship, the documents then comes 6.4 at page 68. Notification comes, page 68 is this.
These are all notifications.
Now,
again, that is also a notification.
No, this is a notice. Page 68 is a notice.
There is a notice.
68 is a notice to all interested parties. Lordship kindly comes.
This notice is also by
Department of Commerce.
Now, no, this is also by a notification.
No. See, Rule 6.4 is not.
Just a minute. I'll just take it out. Just give me one moment. Give me 1 moment.
6.4 doesn't require notification.
Very well.
Rule 6.4.
Then how will a person come to learn with regard to this? If that is so.
That is 5. 5 is the notification. 5, Lordship. Initiation of investigation. That is.
So very initiation requires everyone to be kept informed. And thereafter notice is there, followed by a notice.
Now here the notice is sent to whom? Can you see page 68?
Page
68.
Yes.
To all interested parties, now see the schedule of interested parties that is referred to at paragraph 2. All parties will be mentioned in annexure 1. Now, where is annexure 1? Page 70. Annexure 1. The 5th entry, the 5th serial number is Indian Paint Association.
So on the basis of disclosure made by the petitioner, means the persons who have proceeded.
Followed by, this is followed by their representation, the information, page 77. Sent by page 77. This is the information supplied by them. 77 from DSK Legal Delhi to Ministry of Commerce Industry. Then next comes page also 8. Yes. Page 85 again, Delhi to Delhi. That is the page 85. Now, Lordship, comes page 87. It is the ministry's letter to all interested parties.
This DA has also been published.
Hello?
The DA, the determination has also been published.
Hearing has happened. That's in the official gazette, like in Swaika. It was published in the official gazette. Now, Lordship, Lordship kindly comes to a hearing notice. Page 312. It took effect. It was not required to be served. The final document. It took effect. Then it was published.
Yes.
Now, Lordship kindly comes to
312.
It starts at page 307. 307. 307 is the final finding. Kindly refer to here, page 312. I want to show page 312. Paragraph Z. This is the Rule 66 hearing. Rule 66 hearing. This is the uniqueness of, unlike other levy of tax. In accordance with Rule 66 of the rules, the authority provided an opportunity to the interested parties for presenting their views orally regarding the subject investigation through a public hearing held on 29th of October. Interested parties who presented their views in the oral hearing were requested to file submissions of the views expressed orally, followed by rejoinder. This hearing was also in Delhi. Now, this is as per Rule 66. This brings us back to post oral hearing, written notes were to be submitted. This was also submitted accordingly, page 89. Page 89 under Rule 66 hearing. Hearing takes place in Delhi. This is not an ordinary levy of tax, but this is statutory hearing is taking place. Page 89.
89 is written, this is written submission.
Yes, that is submitted by the GSK Legal to the ministry in Delhi. That's part of Rule 86 and 87. Sorry, 66 and 67.
Yes.
This then comes to, thereafter comes the Rule 16, disclosure statement, which is at page 167.
Yes.
Rule 16, disclosure statement. This is also not notified. This is a disclosure statement sent from the Ministry of Commerce to them, to their lawyer in Delhi, where this is under Rule 16. The essential fact is disclosed. And plus, they are invited to give their comments. Followed by page 225.
The response.
No, it's not response. This is by which they want request for disclosure of the confidential information.
As a request, 30th January.
That's also sent from Delhi to Delhi. From Delhi to Delhi. This is followed by the final determination, that is page 307. That's the notification. Now, Lordship, from the perspective of territorial jurisdiction, may I start with the anti-dumping case, where this final determination was challenged in Madras. Now, Autocompo Stainless versus Union of India. Now, this was also determined from final determination. Paragraph 2B. At page 2. But you kindly come just above the quotation, the fourth, fifth line of page 2. Paragraph 2 continuation. Autocompo being the page 4. However, on 14th November 2011, impugned final findings recommending the levy of anti-dumping duty was passed, wherein the recommendation is to the following effect. That was the recommendation for imposition of anti-dumping. Now, kindly come to paragraph 6, where the issues are framed.
Yes.
Heard the learned counsel for the appearing for the petition respondent number 1. Respondent, I have produced the document available on record. The 3 issues that arise from this. Whether any cause of action has arisen within the territorial jurisdiction of this court so as to entertain the litigation. Now, after Roman 3, to decide the first issue, whether a part of the cause of action had arisen within the territorial jurisdiction of the court, so to entertain the petition, it is necessary to understand the term cause of action. However, the term cause of action has not been defined in the Constitution nor in SIPs. In the case of Kusum Ingots, 4-6 SCC, the Supreme Court considered the scope of expression cause. This is the case your Lordship was referring. Paragraph 6 from Kusum Ingots. Cause of action implies the right to sue. The material facts which are imperative for the suitor to allege and prove constitute the cause of action. Cause of action is not defined by any statute. It has, however, been judicially interpreted inter alia to mean that every fact which would be necessary for the plaintiff to is traversed in order to support his right to the judgment of the court. Negatively put, it would mean that everything which is not proved gives the defendant an immediate right to judgment would be part of the cause of action. Its importance is beyond any doubt. For every action, there has to be a cause of action. If not, the plain petition, as the case may be, shall be rejected somehow. In yet another case, in the case of Alchemist versus State Bank of Sikkim, the Supreme Court considered the scope of action ethics 2 and cause of action in more detail. In paragraph 20, it is stated as follows. It may be stated that the expression cause of action has neither been defined in the Constitution nor in the Code of Civil Procedure. It may, however, be described as a bundle of essential facts necessary for the plaintiff to prove before he can succeed. Now, Lordship, I will not trouble my lord with all these facts. Lordship, kindly comes to paragraph
9.
9. Very good. 9. Hence, taking into consideration all the above principles enunciated in the judgments of the Supreme Court, cited supra, the principle that could be culled out, that is that the facts pleaded must constitute a material, essential, integral part of the cause of action. In the present case, the petitioners pleaded cause of action in paragraph 20 of the affidavit in support of a petition to this court. The petitioner is an exporter of one of the said 3 grades in India, and for the balance 2 grades, they have received purchase inquiries from various domestic and the same is under consideration. One of the ports through which goods are exported by the petitioner is Chennai. Grade so and so is regularly imported by various importers in Chennai port. Exported consignments of the said 3 grades of the subject goods on which anti-dumping duties are likely to be recommended by the respondent number 2 have to be paid when cleared from the bonded customs warehouse at ICD Chennai by filing bills of entry as proved under the Customs Act. Thus, assessment of duties upon clearance of the subject goods exported by the petitioner presently takes place at Chennai, that is within the state of Tamil Nadu. Thus, the injury by way of assessment and payment of anti-dumping duties on the 3 grades of the subject goods exported by the petitioner would be caused to the petitioner within the state of Tamil Nadu. Thus, as aforesaid, most of the consequences of the issue involved in the present petition shall fall on the petitioners within the state of Tamil Nadu, and therefore the petitioners are constrained to approach the High Court for appropriate relief. Next paragraph. From reading of the pleadings stated above, it is clear that anti-dumping duty is payable when the concerned goods are cleared through the Chennai port. That is, assessment of duties upon clearance of the subject goods exported by the petitioner takes place at Chennai. So the issue is whether the assessment and payment of anti-dumping duty on the goods that is going to take place constitute a material, essential, or integral part of the cause of action. It certainly does not constitute cause of action. An anticipatory event will not give cause of action. That may be cause of action for interim relief.
This is not the case here. This case is different from
this. Is the same case here, because if it is levied, it will be suffered here. May I just read that paragraph from reading of the pleadings?
From the reading of the pleadings stated above, it is clear that line.
Anti-dumping duty is payable when the concerned goods are cleared through Chennai port. Same here. Anti-dumping duty. That is, assessment of duties upon clearance of the subject goods exported by the petitioners petitioner takes place at Chennai. So the issue is whether the assessment and payment of anti-dumping duty on the goods that is going to take place constitute a material, essential, or integral part of the cause of action. It certainly does not constitute cause of action. An anticipatory event will not give cause of action. A cause of action must exist, and it is a condition precedent before initiation. May I switch to their paragraph
23.
27?
Will.
I'm reading.
Will. You have read it. Will.
So, will suffer in case it is levied, in case recommendation is accepted. By no means the above factor constitute material, essential, or integral part of cause of action. It is also pertinent to know that the petitioner is non-resident company and who resides in New Delhi. That's nice. Now, Lordship, kindly, taking into consideration the principles enunciated in the judgments of the Supreme Court in the case of Alchemist and Kushumin gods, this court is of view that no cause of action has arisen within the territory. Because it will happen in future. Cause of action has to arise. Cause of action is not something, a cause of action may arise in future. So when that duty is levied, then I will get the cause of action. Not, I have a cause of action now. Because it is like challenging a bill introduced in the parliament. Can I challenge a bill? If the bill is passed, then there'll be inheritance tax. And I will be subject to inheritance tax. Bill may be passed, may not be passed. The upper house, it may be passed by the lower house, may not be passed by the upper house. A bill, when it is introduced, will it be a cause of action? Because I may suffer inheritance tax in future.
This says that when there will be a cause of action, when it is cleared through Chennai port, then the question of levy is there, and then the cause of action will be there.
Cause of action must exist, and it is a condition preceded for
So
it.
according to the learned judge, the cause of action did not exist on that particular date.
Because it may be levied, final determination may not be levied. Once it's levied, then immediately, of course, the petitioner's goods will be subject to
Petitioner
custom.
did not have the cause of action for instituting the suit. Not that the court did not have the cause of action. There is a difference. My understanding, I may be wrong. Correct me. There is a difference between the petitioner or a party not having a cause of action to file a claim and the court lacking the jurisdiction by reasons of the party not being able to make out a case that no part of the cause of action has arisen. There is a distinction.
Of course, there is an absolute distinction. Both are separate principles. One is not yet have a cause of action.
That is what is here. Not yet there is no cause of action as on this date.
As on this date. That is Jindal Polyfill Board.
Yes, and this case also says so.
Yes, also. Now that can also lead to the cause of action for filing the case or the territorial jurisdiction of the court, because the cause of action has to arise. Now, Section 20 of CPC.
Yes.
Cause of action has to arise within jurisdiction. What is the cause of action within jurisdiction? Is the levy of the duty.
You are saying there is no cause of action at all. Today, petitioner does not have a cause of action for moving the court. So whether the petitioner will have a cause of action or not need not be tested at this stage.
Well, that's my first part of my submission.
Yes, assuming it has.
Assuming it has, now you are not being levied with a anti-dumping duty as yet. Your manufacturers in Calcutta have not yet suffered.
Yes, petitioner does not have a cause of action, although it is premature, is more or less goes on the same lines.
Now, then in that case, if you are simplicity challenging the final finding, then you are challenging this as a quasi-judicial final determination. Not, it is like article, like the decision you are challenging, which is again, according to my first part remains. This is my second part. It is inchoate, as used in Jindal Polyfill. It is not yet. But now let's just, so there is no cause of action. Now, leaving that aside, today, if at all there is a cause of action, it's not the sufferance. It is future cause of action which may arise out of
After the final adjudication, after the levy is there, recommendation is either accept may or may not be there. Mr. Sharma had argued. And only if the levy is there, then only question of cause of action arises.
then the cause of now today, if at all there is it is not premature. What are you challenging? It's a quasi-judicial body's final or recommendation. Quasi-judicial, I'm saying why? Because there's the opportunity of hearing has to be given and notes filed, notices issued, interested parties to be heard, and then a quasi-judicial authority's determination. That is in the realm of a certiorari jurisdiction, which will be in the court where the determination has happened. This will take me to Kushuminga. Kushuminga, give me a 4. (2004) says 325. I'm saying if at all this was justiciable now, as a paragraph 12.
Paragraph? Yes.
This court in ONGC versus Utpal Kumar Basu held that the question as to whether the court has jurisdiction to entertain a writ petition must be arrived at on the basis of averments made in the petition, truth or otherwise thereof being admitted. This court in ONGC's case held that all the necessary facts must form an integral part of the contract. It was observed so also the mere receipt, the mere fact that we sent the facts from reply without cause of action. State of Rajasthan was Swaika property. This court opined that mere service of a notice does not give rise to any cause of action unless it was an integral part. The said decision has also been noticed in ONGC. The answer to the question where service of notice is integral part of the Aligarh Muslim University, we are surprised. This is not so important, Lordship. Kindly come to paragraph now. Paragraph. No, not paragraph 17. The paragraph 19, yes. Passing of a legislation by itself, in our opinion, does not confer that right to unless a contradiction arises. The distinction between the legislation and the executive action should be borne in mind. Parliamentary legislation, when it receives the assent of the President of India and is published in the official gazette, unless specifically excluded, will apply to the entire territory of India. If passing of a legislation gives rise to a cause of action, a writ petition questioning the constitutionality thereof can be filed in any high court of the country. It is not so done because a cause of action arises only when the provisions of the act or some of them which were implemented shall give rise to civil or evil consequences. To the petition, a writ court, it is well settled, would not determine a constitutional question vacuum. The court must have the requisite territorial jurisdiction order passed on a writ petition questioning the constitution of a parliamentary act, whether interim or final, in keeping in view the provisions contained in clause 2 will have effect throughout the country. A writ petition However, questioning the constitutionality of a parliamentary act shall not be maintainable in the High Court at Delhi because the seat of Union of India is in Delhi. Counsel for the appellate in support of the argument would contain that a citus of training law or rule would give jurisdiction to the Delhi High Court in support of the said contention relied upon. So far as the decision of this court in Nasiruddin's case is not an authority for the proposition, the citus of legislature of a state or authority. Power to make subordinate legislation or to confer jurisdiction on the High Court or a bench of the High Court to entertain legislation. That this court, while construing the provisions of the UP High Court, held the conclusion as well as the reasoning of the High Court in an application under Article 26 would be as the expression that this course of action arose because of the appellate order or the revision law, which came to be passed at Lucknow, then Lucknow would have jurisdiction. Though the original order was passed at a place outside the areas in out. It may be that the original order was in favor of the person applying for a writ. In this case, an adverse appellate order might be the cause of action. The expression cause of action is well known. If the cause of action arises wholly or in part at a place within the specified areas, Lucknow bench will have jurisdiction. Now, this is paragraph 25. The decision, as Lordship was saying, state decision is the authority for the government that the place from where the appellate order or revisional order is passed may give rise to a part of the cause of action. Although the original order was in a place outside the city, where a part of the cause of action arises within one of or the other High Court, it will be the petitioner to choose this form. The view taken by this court in UP Rashtriya Chini Mill that the citus of issue of an order or notification of the government would come within the meaning of the expression cases arising in clause 14 of the amalgamation order is not a correct view of law. For the reason hereinafter stated and to the extent the said decision is overruled. In fact, a legislation, it is trite, is not confined to a statute enacted by Parliament of the legislation of a state, which would include delegated legislation and subordinate legislation or an executive order made by the state or any other. In a case where the field is not covered by any statutory rule, executive instructions issued in this behalf can also come in within the purview thereof. Citus of office of Parliament, legislature, or state authorities empowered to make support would not by itself constitute any cause of action. In other words, framing of a statute, statutory rule, or issue of an executive order would not confer jurisdiction upon a court only because of citus of law. When an order, however, is passed by a court or tribunal or an executive authority, whether under provisions of a statute or otherwise, a part of the cause of action arises at that place. Even in a given case when the original authority is constituted in one place and the appellate authority is constituted another, a writ petition would be maintainable at both the places. In other words, as order of the appellate authority constitutes a part of the cause of action, a writ petition would be maintainable in the High Court within whose jurisdiction it is situated, having regard to the fact that the order of the appellate authority is also required to be set aside as the order of the original authority. Either the authority who makes the order, position is there, and now if it translates into a levy, then cause of action will arise. Yes. Now, Lordship, let me move to Soika property. Soika. Paragraph 8. Paragraph 8. The expression cause of action is tersely defined in Mullah's book. I am not placing all this. Lordship kindly comes to the fifth line from the the last paragraph. In other words, it is a bundle of facts which taken with the law applicable to them gives the plaintiff right to lead against it. The mere service of notice and 52(2) of the Act, spot that register of 18, within the territorial limits of the state of West Bengal could not give rise to a cause of action within that territory, unless the service of such notice was an integral part of the cause of action. The entire cause of action culminating in the acquisition of land under Section 1 of the Act arose within the state of Rajasthan. That is within the territorial jurisdiction of the Rajasthan High Court at the Jaipur bench. The answer to the question whether service of notice is an integral part of the cause of action within the meaning of 226(2) of the Constitution, but depend upon the nature of the impugned order giving rise to a cause of action. The notification dated February 8, 1984, issued by the state government under 52(1) of the Act, became effective the moment it was published in the official gazette, as thereupon the notified land became vested in the state government, free from audit. It was not necessary for the respondents to complete the service of. If the respondents felt aggrieved by the acquisition of the land situated in Jaipur and wanted to challenge the validity of notification Rajasthan under 52(1) of the Act by petition under Article 226 of the Constitution, the remedy of the respondents for the grant of such relief had to be sought by filing such a petition before the Rajasthan High Court Jaipur branch, where the cause of action fully or in part.
Yes.
Now, my lord, so this notification upon being published took effect immediately. Loss may be suffered, may not be suffered. Cause of action may arise if the levy is imposed. But as of now,
so you accept the fact that even when levy is imposed, cause of action will arise here.
if the levy, if the final determination is converted into a levy, and then of course, my first case will be based on authorities that association cannot. Because the levy is
that is a different
matter. Then yes, then as if you were asking me,
because today I understand your contention is basically that the plain does not, as we say, the plain does not disclose cause of action. Here you are intending to say the case made out by them does not disclose cause of action to move the court because the levy has not yet been effected today by relying on that Madras High Court judgment. And as and when levy is there, then the question will arise as and when recommendation is accepted. Today, recommendation is yet to be accepted.
Then jurisdiction will be if somebody has to pay the duty here.
Then the person who has to pay the duty, as and when he exports it, because the import. Here the question of import. As and when the import is there, then the levy will be there.
They have to file their bill of entry and they have to pay that the levy.
So that will be within jurisdiction.
That will be, of course. That's what I'm saying. Well, I am. When the levy is imposed, because they will suffer a financial loss within West Bengal jurisdiction. The High Court will have jurisdiction, of course, but not at this
stage.
Not at this stage, because this is
basic argument is that this is premature to that extent that this court, as of today, does not have the jurisdiction to entertain because no cause of action today has arisen within the jurisdiction of this court.
It is premature, so the petition itself is premature. And if at all you are challenging the final finding as a quasi-judicial authority's determination, then you go there. It is like one last judgment on this proposition, Shenamuldo. And the two, two more. Give me Shenamul.
How long will you take? This is the
But
more
then
or
I
less-
shall have to go on the disclosure of my confidential. Give me another.
means timeline like
I may need
half an hour.
may need 15 more minutes next day in case I don't.
No, then you concluded today. 15 more minutes, I think you can conclude thereafter. Original side mentioning, I will take and fix it on.
Lordship, then do something. Lordship, kindly take this up tomorrow. I will finish my
Because you see, I'll tell you why. The original side list I'm not taking up.
Lordship, if it's possible to take it 12:30 tomorrow, 12:30 or at 2 o'clock sharp for half an hour, I'll finish it off for sure. Half an hour, I'll finish. Lordship gives at 2 o'clock, 2:30, I'll finish.
Between 3 and 3:30, you finish it. I'll fix it at 3. I'll call at 3, 3:30 and 3:30, you finish it. Show this judgment and thereafter I'll take up the original side matters.
It comes to paragraph 46.
And thereafter, you kindly, sir, in the meantime, find out whether that letter, get instructions on that letter, original letter, with whether it is with you or not. Yes, that is not written there. I've returned it to you. Yes, yes. No, whether you have received the letter or not, that is not confidential. So you can always disclose that. Yes, Mr. Mitra.
Para 46. The It's a, yeah, 46. 46 onwards, 46 to 50. The judgment of the Kerala High Court in Jyotilal again proceeds on the assumption that consultation was required to be carried out the state of Kerala through the candidate, though the candidate was allocated to the state of Orissa. The judgment proceeds on basic fallacy that consultation has to be with the state to whom the officer is to be allocated, not within the state with whom the officers claim allocation. Now, Lordship, kindly come to para 50 stated. I have not troubled much.
Para?
Para 50. The full bench of the para 50. Page.
Yes, yes, I've got it.
Full bench of the jurisdictional High Court in a judgment in Nakul Deo Singh was considering an original petition filed before the Kerala High Court by head constable working in CISF unit at Bokaro Steel Plant. In the said case, the disciplinary authority and the appellate authority were situated outside the territorial jurisdiction of the High Court. The applicant claimed that since the order of the appellate authority was received within jurisdiction of the Kerala High Court, therefore it will have jurisdiction to entertain the original petition. The court held as under. It appears to us that the decisions in Swaikapam and the decision of the Supreme Court and that of the High Court subsequent there to clearly establish that the receipt of communication by does not constitute a part of a fact or in the bundle of facts constituting cause of action. At best, receipt of the order of communication only gives the party a right to action based on the cause of action arising out of the action. When that action complained of takes place outside territorial jurisdiction of the High Court, and in appeal therefore is dismissed by an authority located outside the jurisdiction of the High Court, cause of action wholly arises outside the jurisdiction of the High Court. 210.6.2 cannot be invoked to sustain a petition in this court on the basis that a part of the cause of action has arisen within the jurisdiction of this court, merely because the appellate order communicated from the seat of the appellate authority was received while the petitioner was residing or working within the jurisdiction of this court. Acceptance of the argument that situs of the receipt will determine the jurisdiction can lead to a position where litigant would be in a position to choose his own court for the purpose of redressal of his grievance. All that
this is with regard to the service matters where the situs is important, more important. For instance, if a person is working in Calcutta and he has gone to a different state where he received his order of dismissal, he cannot challenge that order of dismissal in that state by saying that the effect of the order of dismissal has been felt there. The situs is important. He has to,
where the order is made.
yes. So he has to come back to Kolkata and challenge it in Kolkata.
That will be also like, this is.
But that is
If your
different.
duty happens, it is that. It's
That is only in respect of the service matters where that site issue of situs is taken into consideration where the person was last residing, last working. And here also in this case, you see, he was in Bokaro Steel Plant as a head constable CISF. That is Bokaro, and matter was filed in Kerala.
Because he was received the order, he was working.
So that would not give jurisdiction. That is subject to correction. That's very settled.
That is very settled. So now, because the quasi-judicial authority decision is in Calcutta.
Here the case is a little different. At least from the service matter.
Yes,
but your contention that premature, certainly I will consider that aspect.
So once the levy is, till the levy is imposed, it is only a determination. A determination of a quasi-judicial authority happening, if at all justiciable, will be the court within whose jurisdiction the quasi-judicial authority is situated. If at all justiciable. My first point, it is not justiciable.
Very well. Mr. Mitro, then tomorrow at 3. Between 3 and 3:30, you will conclude.
Let's I learned.
I don't think they'll take much time. You'll take around 10 to 15 minutes. 2 3 minutes.
Manoj, we'll try our level best.
No, I'm saying whichever day you want, tomorrow you tell me.
Manoj, we'll indicate.
Tomorrow you indicate, because you get to know that Mr. Mitro is concluding tomorrow. So you indicate tomorrow. Heard Mr. Mitro, learned senior advocate representing the respondent number 5, lists this matter for further consideration under the same heading. Calcutta date day, within bracket 3 p.m.
Grateful.
Yes, Mr. Sharma.
Grateful.
Yes, original side mentioning, please.
My lord. Yes.
Yes, mentioning, please.
My lord, I am mentioning a matter from list, days list. My lord, that is item number 64. Your lordship may remember in this matter, argument has been completed and the official liquidator was directed to
wait this way. Entire week you have to wait. I don't think both Mr. Mitro and Mr. Sharma are there, and thereafter I have to hear Mr. Mukherjee. So tomorrow again 3:30. Say I don't know. It may spill over for a little more time because tomorrow Mr. Mitro will conclude. I'm not. Thereafter you mention next week, sir. Kindly come and mention next week. I'm not considering your mentioning this week. It's very difficult for this court to take up. You understand? I have to conclude this matter.
Well, this is not for hearing, but this my pair is for appearing as to be mentioned. Well, there is the direction.
Come and mention next week.
Your Lordship, may I be permitted to mention a matter? Your Lordship, this matter was mentioned last week, wherein Your Lordship had directed for inclusion of the matter in the list, monthly list. However, Your Lordship, this matter is not appearing.
Yes, Mr. Yes, sir.
My Lordship, may I be permitted to mention a matter regarding upgradation of a matter?
Upgradation, don't mention this week. Next week. Come next week. You see, I have to take up these matters tomorrow also, and another day this week.
My Lordship, the GST registration has been restored by the appellate authority, but till yet registration order has been passed, but till yet it has not been restored. It is very urgent.
We mentioned day after tomorrow. We mentioned tomorrow the other. We mentioned tomorrow. After this 3:30, after 3 o'clock matter, your matter will be taken up. Yes.
Lordship, one more
No,
item.
no more mentioning. Yes.
Inclusion of
yes,
the list.
madam.
My lord, in these writ petitions, there was a dispute regarding the classification of fly ash block. My lord, that has been clarified by the circular dated 14/25, my lord. So this is a very short issue, my lord.
Mention next week, madam. Mention next week. Let me go through these matters this week. Yes.
Your Lordship,
Fly ash matter, I'll take up. Remind me next week, I'll take up the fly ash matters. I remember, I've taken up this matter, perhaps? No.
No, my lord. My lord, there is a common issue, common.
Hey, hand over the slip flyers दिए था देखे ना yes.
Can I just seek your lordship's kind indulgence to trouble your lordships once more with that matter, the Dunlop matters, your lordship. Two
Mr.
applications were there.
Chakraborty, I cannot take up this week.
But
Next
just for
week.
inclusion in the list, your lordship.
Yes,
Then let
next
it
week.
run.
Parish Shapta debe.
Yes,
Parish-
sir.
Next week. Takut.
My lord, I am from the petitioner. My lord, in this matter, my other side was Justice Rai, and Justice Rai, an interim order was passed in this matter in the year 2022, and we have mentioned this matter last month because there was a threat from the assessing officer to pass assessment order. Though he has not passed the assessment order, but we are ready with the matter, and this issue is covered by the judgment of Honorable Supreme Court. But my this
Not today. Not this week. And line दिए दो, since the respondents are not represented, let this matter stand adjourned and appear.
These matters are a batch. There are 6 matters. The reason why it was mentioned, my learned junior had mentioned it because the affidavit in opposition which has been filed accepts that there was non-consideration.
They've served it.
Or they've served it. They've served the affidavit in opposition, which shows. I'll quickly give a background. The petitions under section 264 were filed before the commissioner. I had filed my return on the basis of salary that I had received. That salary which was the managerial remuneration was subject to approval. Number that approval.
Why is it appearing under the heading to be mentioned?
So the affidavit which they have filed, I'll just give that background quickly. So the approval never came. So the company wanted me to return the money. Under the Companies Act, I was holding this money in trust for the company. So I returned the money. Then
we just come again once again.
Gotcha.
What money, sir? Kindly explain.
I was holding a managerial position. I was a managing director, deputy managing director. There were resolutions sanctioning a certain remuneration for me, which were in excess of the stipulations under the Companies Act. So the application was made to the central government for approval for paying me the higher remuneration. During the pendency, the amount was paid, the higher amount, and then the law changed that it is not the central government but the shareholders who will decide, and the consent has to be taken of the lenders, etc. So then the company then decided that I should refund the extra remuneration. Now I had filed my income tax return on the basis of the amount that I had received. Tax had been deducted. I filed my return showing that higher amount. Now the company asked me to return it under
how many years?
About 3 years. So then because there's the time the application was pending with the government, then the law got amended. Then the company had several courses of action open to it. It decided ultimately to ask for the money back. So I refunded it. Now within about a month of refunding the money, I applied under section 264 before the commissioner that I have offered to tax something which was provisionally lying with me, because the Companies Act says that the extra amount is lying in trust with me. So I have been subjected to tax on this higher amount, and please direct that the assessment be made with reference to the amount actually which is my income and not the higher amount which is given to me. So the commissioner, this application was filed for each of the years within about a month of refunding the money to the company. So, but by that time, the statutory period is about 1 year from the end of the from the time that the order is passed. So I can apply for revision within 1 year from the end of the month in which the order is passed. So this time was gone because by the time the company asked me to give it, so the commissioner passed an order saying that he will not condone the delay. The delay
For filing the return.
for not making this application. Return was filed in time. So no,
your initial return was filed showing that you are holding, showing that you have earned this remuneration.
Yes, absolutely.
Now you wanted to file a rectification of your returns.
No, that time was gone. So the only way was for me to apply to the commissioner under section 264. That power is with the commissioner. He can revise an order which is prejudicial to the assessee.
বইটা দাও তো, ইনকাম ট্যাক্স ওই দেখা যাচ্ছে, ওই তো। Yes.
To 64 minutes subsection 1.
Subsection 3 comes against you. Difficulties, it says it has to be within 1 year.
Yes, no, therefore there is a timeline. There's no doubt about it that there's a timeline. Now, I had explained that because not till such time as the company asked me to give the money back, I had no reason to go back to the income tax department, because not I had offered to tax what I had received. Now, till such time I was asked to give the money back, the company could have decided to leave it with me, and it would get the approvals from the shareholder. But not the company decided that I should return it. As soon as they asked me to return it, I returned it within the same month, and then within a month, I approached the commissioner. So the commissioner, so this explanation was given. It was given, but the order does not reflect the consideration of this explanation, because my explanation was that till such time as I was asked to give this money back, I could not come to the department. So this part, he accepts in his order that this explanation was not considered.
They have filed an affidavit.
Yes, they served it. The other part was on merit. On merit, I had filed submission before the commissioner saying that I am not seeking a reduction of the. If my lord is pleased to see that
you are not seeking
that the commissioner said that there's no provision in law enabling reduction of allowing a deduction from the amount assessed of any money returned by me. He says that I cannot allow deduction, say, of the amount that you've returned. My answer was that this is not a deduction that I'm claiming. What I'm saying is that this was not income at all, because it did not belong to me. I was holding it in trust. I had offered it to tax because it was given to me, but the company has
there is one difficulty here. Dr. Kaitan. When you were holding it, you never said that you were holding it in trust. You actually were holding it. Now, if you were all along holding this in trust, and you had offered this to tax, then it would have been a different scenario.
But I had offered it to tax. My pleading is it was a mistake on my part in offering it to tax, because it did not belong to me. What was allowed to me under the law was the minimum amount, but this amount, the Companies Act provision itself stipulates that it will be held in trust by me, and I have to. It's not something of my making. The law enjoins that I hold it in trust if I have received it. Now, this in fact this question has fallen for consideration by high courts also.
And you paid the tax.
I paid the tax. Tax was deducted. Tax was deducted by the company, and I also, whatever shortfall was there, I made it up. So, since the money was with me, I paid tax on it. Now, the company has asked for it back. I have returned it. Now, I'm saying that this was never my income. So, please.
How much tax did you pay on this?
Full tax.
TDS was deducted 10%.
I paid full tax. Up to the rupee. Now, the commissioner in the order he proceeded on the basis as if I was claiming deduction from the income assessed. My answer in writing was, I'm not claiming any deduction. I'm saying that this was never income at all. Now, in the affidavit, he says that though this point was taken, it was not considered by me. Kindly see 3 paragraphs.
In the affidavit, it is said.
Yes, kindly see 3 paragraphs in the affidavit. Kindly take paragraph 9, 10, and 17, page 5.
Okay, so page 5.
How much did you refund?
No, the entire excess quantum. No, it's more than 1 crore. No. It's a very large sum. No, and also kindly see paragraph 17 at page 8.
Where is the order?
No, the order is at page 122. And at page 125, paragraph 5 is, my lord, will find the reasoning.
The amount refunded is here. So page 72. So the amount refunded, सारा साल का
Page?
So 72. So reverse order. Salary has remained the same, 3.21 crores. The of the minimum remuneration permissible requirement, HMS of the amount refunded.
This is the amount that I've written, 74. Now, kindly see at page 74 of the figures amount returned below. Page 74, if my lord is pleased to see, it has not received attention. So it seems that if the matter goes back, let them consider and decide, because presently the order shows no consideration. It's simply a line is written that delay is not explained without really referring to the reasons forwarded. The legal contention urge is not considered. They're saying that it will proceed on a different legal footing altogether, as if I've claimed a deduction. So,
is the officer competent to condone this delay and revise?
Yes.
Yes. So under what provision is it?
Under section 264.
Under this section.
No, he has the power to condone the delay as well. Kindly see. Kindly take subsection 1. In the case of any order, other than an order to which section 263 applies, passed by an authority subordinate to him, the principal chief commissioner, principal commissioner, commissioner may, either of his own motion or on an application by the SSE for revision, call for the record of any proceeding under this act in which any such order has been passed, and may make such inquiry or cause such inquiry to be made, and subject to the provisions of this act, may pass such order thereon, not being an order prejudicial to the assessee as he thinks fit.
Proviso to subsection.
And then subsection, may read subsection 2 also. The principal chief commissioner so-and-so shall not of his own motion revise any order under this section if the order has been made more than 1 year previously. And 3, in the case of an application for revision under this section by the assessee, the application must be made within 1 year from the date on which the order in question was communicated to him, or the date on which he otherwise came to know of it, whichever is earlier, provided that the principal chief commissioner, etc. may.
Proviso is there.
Yes, if he is satisfied.
Come tomorrow. Same position. Whatever you want to submit, I'll hear you tomorrow, Mr. Sharma.
I'm just thinking about after submission of my senior friend.
Yes.
Many things. Just a question arises in mind. The return is processed on the basis of whatever is shown in the return.
You are not wrong. Your stand is not incorrect. But you see, they are saying that the order is not very clear whether this has been considered or not. Discretion has been exercised. Ordinarily ought not to be interfered with. Come tomorrow, argue the matter. Or Mr. Khaitan Nandit, senior advocate. All the matters?
All the matters.
There are
Different years, 2
petitioners
persons.
in the above read petitions? Okay. We are opposition in all matters.
All matters.
How many petitions?
I have filed one. There are 5 more.
5টা দেখে নিও ওপরে affidavit in opposition filed in court is taken on record. Affidavit filed in court on behalf of the respondents in court today is taken on record. For Mr. Khaitan Lanet, senior advocate representing the petitioners in the above petitions. Full stop. তাহলে একটা ইন্ডিভিজুয়াল অর্ডার আলাদা আলাদা করে দাও কি হবে আমি জানি না আলাদা আলাদা petitioner representing petitioner in the above read petition. Full stop. List this matter for further consideration on the same heading tomorrow. আজ সই করে এখনই পাঠাও এখনই আগে এটা পাঠাও
I'm grateful.
Mr. Khaitan, first that matter will be taken up.
Hello.
Thereafter mentioning and thereafter I'll take up your matter. That's it. শুধু আপনি একটা তিন দিন আবার তো হচ্ছে না একসঙ্গে আলাদা আলাদা অর্ডার হচ্ছে ঠিক আছে he has a discretion too, but he has exercised his discretion
without considering.
That is the only part.
And that
I'm sorry.
No, not on merit, my friend. But in fact, there are judgments on this point in support of the assessees.
Show me 1 or 2 judgments.
I will show. On principle,
only one.
It has been said because this is not income. What is not income has been assessed. So therefore, in all fairness, this money ought not to be taxed. It's not my income. I had to return it. Salary paid to me provisionally.
But you had not treated the same as such.
True.
This has intermingled with and come within the till of your funds that you have received.
Therefore, I paid tax. No.
Yes, therefore
But
you have
then,
paid tax.
if in law, it is not to be regarded as my income, but it's a mistake in my return, and I can get it corrected under 264. I can get it corrected
even after 1 year.
Yes. No, of course, subject to condonation of that.